Some of the matters we have already filed our affidavit, Lordship. Lordship will fix for admission hearing after vacation, Lordship. Perhaps today, the petitioners council is having some difficulty.
Have you informed the petitioners council?
Lordship, I have already informed him, and he also rather informed me that he has some difficulty today to
After the puja?
after Puja vacation, Lord.
Okay, on request made by Mr. B.N. Chamba, the studying council, elementary.
Elementary, Lordship.
This matter after the puja.
15, 16 and 17.
Then 16 and 17.
Or like.
My lord, I have a prayer in item 33, my lord, supplementary, my lord, order, my lord. My lord, in this case, my lord, I have taken steps upon all the respondents, my lord, and the step is complete, my lord. Let the matter be listed in the admission stage after vacation, my lord.
Let it reach.
My lord, the respondent is also present here since, my lord.
Let it reach. Let your item reach.
My lord, wait.
I pray for listing of the order column on any date next week.
Order column.
Yes. Content case.
What is the urgency for next week?
So notice has been issued on 22/7/2024. Thereafter it is not listed. Before vacation on any date.
Okay. Third.
May I please, Your Lordship? In item number 30 in supply list, can be matter and be fixed at 2 p.m.
Why?
It is a IIT Padhar matter, Your Lordship. And if the matter is not this, it will be infractious. I already informed the respondents, IIT.
How it will become infracted?
Their examination is conducted, but in the earlier occasion also in the hearing, IIT stated that they have given all the reliefs, but in our case, the reliefs of not.
It is only the issue of the stigma on the petitioners. That's all. Not a question of getting infractions.
No, Your Lordship, they have to prove how I was involved in this case.
That's why.
Matter.
That's why.
If not, it is not raised, then it will be come after vacation. It will be infracted, Your Lordship.
Okay.
My Lord. May I have the Lordship? May I have the Lordship? Like I mentioned for listing, one repetition, Lordship. Matter pertains to Anganwadi worker, Lordship. Lordship. Urgency is that, Lordship, she was suspended in a misappropriation of money in case, and thereafter she was acquitted. But department did not allow to join in her post, Lordship. Particularly Friday, Lordship. But she was old lady, Lordship, widow lady. Friday, Lordship. Much obliged, Lordship.
Lordship, I would to mention orders matter. Lordship, the matter was last posted on 10/5/2024. Lordship, kindly listing the matter any day after Puja vacation.
After puja. Then will come up after puja. You mentioned after the puja package. I'm not fixing this after the puja.
Blessed.
My pleasure, Lordship. I beg to mention item number 24, my lord. This matter regarding recognition of BID college. On the last occasion, my lord, hearing could not be completed due to paucity of time. Kindly upgrade at 2 p.m., madam.
No, I've already upgraded one matter at 2. One matter is already upgraded.
It will hardly take 10 to 15 minutes. It will hardly, it's simple order will be.
Okay. After the upgraded. Yes.
May I please, Your Lordship?
Yes.
May I please, Your Lordship? My lord, I pray for listing of item number, repetition number 4129, Your Lordship, for motion matter, Your Lordship, pension related matters. That will be listed on 27, Your Lordship, Friday.
Okay.
Obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 11, Lordship. Kindly adjourn for a day, Lordship.
11.
Yes, Lordship.
You are appearing on behalf of?
Mr. S.B. Laskar, Lordship.
Okay, on request made on behalf of West Alaska. Please, the matter of 2 weeks.
May I please, the Lordship? Lordship, praying for listing of a WPC in admission column regarding area of salary before vacation any date, Lordship.
Okay, first.
Obliged, Lordship.
May it please, Your Lordship? May it please, Your Lordship?
Yes, please.
I beg to mention item number 29, Lordship. I'm seeking an accommodation today and I'm making a joint request with the respondent number 1 for listing the matter on 29th of October, Lordship.
29th of October.
Yes, Lordship.
Okay, on request made by the party.
May I please your lordship, I'm appearing for respondent number 3.
I'm appearing for respondent number
Nothing
1 and 2.
on
Your Lordship.
request made by the parties.
May I
Grateful,
please your lordship, I am requesting for a listing of a matter, your lordship. The urgency is that the petitioner is not getting any salary. He was suspended because of a disciplinary proceeding. Any date, your lordship, for admission.
Before puja,
After puja,
you mentioned after puja, puja, after puja.
any date, your lordship, any date.
Okay, 28th October.
Item 1 of daily list, motion.
May I please your lordship. My lord, this is a matter pertaining to my lord compassionate appointment, my lord.
Hmm.
And my lord, I applied on time, my lord, just after 1 month of the demise of my mother, my lord. And accordingly, because of want of vacancy, my lord, my case was never considered, my lord. Therefore, my lord, I am praying before this honorable court to consider
Yes,
my prayer, my
any
lord.
instruction?
To have
Well,
one
the instruction, direction was to obtain instruction whether that rejection was communicated. After some time, I have delivery communication, after some time. Otherwise, it was rejected back in 2016,
Ah, that's
so no case.
after,
remains.
after some time. Let
Well,
2, admission.
Hey, physiology. Also, the matter relates to regularization of contractual professor, service of contractual professor. And last occasion, Lordship, the 6 numbers of similarly situated service of assistant professor has been submitted before the cabinet, and ultimately cabinet Lordship considered only one case, who is also similarly situated along with the petitioner. But so far the petitioner is concerned as to why his service is left out. No reason is assigned. So after hearing on last occasion, your lordship has directed the state respondents to obtain the 2 records pertaining to which cabinet has taken a decision to regularize the service of such assistant professor. I have not gone through the records.
Das,
Okay.
you have got the record.
I have received the record or not? You got personally
received the record, you see.
There are 2 records.
Have you flagged it?
First one is Lordship, cabinet approval, Lordship. Cabinet memorandum is there also, and other is record.
The issue is as to why the cabinet has not considered the service of the petitioner.
Where? Which
Look
flag?
in the first one, Lordship, Lordship, cabinet. My
The
lord,
not sheet.
no, Lordship. First, white sheet.
This one.
কিবা আছে নে memorandum?
Lordship, that white page is not here.
Like mat koi diya na.
White page. Lose. First one, Lordship.
This one.
This one is the cabinet approval.
সেলাই তো করে গেলে সব সিং
Who is the cabinet memorandum?
This one, next page,
Next.
Lordship. Next page, Lordship. My lord, may directly come to paragraph 5 of the cabinet memorandum, Lordship.
রেকর্ডার আনিব নাকি না রেকর্ডার দিব না actually কি আছে ক্যাবিনেট রেকর্ড তো সবার জন্য সাইন
Paragraph 5 indicate lossy cabinet memorandum lossy paragraph 5.
You okay, out of these two,
Lossy.
one had resigned.
And regarding petitioner lossy, paragraph 5 stated that he is not having the requisite qualification. That's why he is not approved by the cabinet at the relevant point of time. Otherwise, also lossy, the decision of the cabinet is lossy not by the statutory prescription. It's an extraordinary decision taken by the cabinet lossy. But if you go by that lossy, statute that lossy, it's a illegal decision taken by the lossy. Today I cannot say whether it's a legal or illegal. Otherwise, we bound by the prescription prescribed by the statute lossy. And cabinet has lossy taken extraordinary decision where they have found that he is not requisite qualification, so his case was not considered at the relevant point of time lossy.
Have you gone through
I
the?
have not gone through the records. I have not seen lots.
He can
And so far the affidavit also. Already in the affidavit, that is the reason. In the affidavit also, they have stated because now he is not having the
You want
requisite
to go through the report, you can go through.
yes, qualification. I will go through it. But so far the qualification is concerned. He is having that qualification. In fact, the director of the technical education, he himself stated, I am having the requisite qualification, number one. And prior to that, Lordship, the selection committee of the governing body of the college, they also considered the case of the petitioner, and accordingly he was appointed after having the requisite qualification. Here they have misinterpreted, Lordship. Here, Lordship, my branch is computer science and information technology. Now, so far the present director, although he filed affidavit, is stating that since it is an engineering college, I am not having the requisite qualification for appointment of assistant professor in an engineering college. That is the crux of the matter, Lordship. In all the correspondence, if you go through it, the record, we found that my department is computer science and information technology. That is, they have wrongly misinterpreted.
Well, why you let him go through the?
Lossy, he can go through it. Otherwise, just like clarify, Lossy.
No,
He is
it's
the
okay.
qualification of the MCA. MCA is an extra department, independent department of engineering colleges, Lossy. He is not appointed against the MCA department.
Okay.
Not required, Lordship. Lordship,
He is an engineering and technology department. The requisite qualification he has not. Lossy.
is no. That is
When
that,
shall we have it? After puja?
if that is the only reason, Lordship, that I am not having the requisite qualification, then I can satisfy you, Lordship, from this record also.
It's okay. If you want to go through, you go through. If you
Yeah.
don't want to proceed, you want to proceed, you can proceed.
Or otherwise, Lordship, the reason is same, Lordship. And since I am not
There-
having the qualification,
And there
but
are
the
some,
document itself, their document, it is not my document that I
there are
have
some flag
never
pages also, if you want to see, it's up to you.
checked. Today is Lordship.
Immediately section put after the
Section code, you. Immediately after vacation, that may be possible.
Okay,
In,
heard.
in the meantime, I may be today allowed to park.
Interim order.
As well as Mr. K. Gogoi, Standing Council, Higher Education. List the matter immediately after. You take back your records.
Yes, yes.
Lossy, Lossy.
But will it fix on?
Immediately after puja. You can make a mention.
That may be fixed, Lordship.
So after.
This is a
puja,
pardon matter,
No,
Lordship.
after puja, many cases will be, so there'll be.
So it will remain as a pardon matter, Lordship. Lordship, the interim order that may be continued.
Interim is that?
Yes, yes.
Interim order procedure to continue till the-
Obliged, Lordship.
3 and 4.
टाइम लगो ना पैसा अपना लेके
Okay, Lordship, here in one of the writ petition, we are going to file our affidavit,
In which writ petition?
2017
2017.
5434 of 2017.
Have you filed your amended writ petition?
In one of the writ petition, we have apparently filed 2939/2020. An affidavit has been filed. But Lordship, perhaps that affidavit doesn't
Which
actually-
writ petition?
The 2939 of 2020.
That writ petition is not listed.
So there are number of
Okay, 29.
Yeah, item number 4, ma'am.
Lordship, I don't know who. And in this 5434/2016, it requires an affidavit, Lordship.
2017.
Lordship.
It's an amended writ petition, ma'am.
Okay. Okay. Head MS,
TJ Sahewala.
DJ Shahiwala, Leonard Council.
My lord, may fix a date. 24th, ma'am.
Mr. P.N. Sharma, Leonard Standing Council, Elementary Education. Is allowed how much time?
3 weeks, Lordship. After
3 weeks
vacation.
time.
After vacation, immediately after vacation. ma'am.
3 weeks time. You file counter affidavit to the amended writ petition in WPC number 5434 of 2000. Please immediately after the puja petition.
Obliged.
Obliged.
5.
May it please your lordship.
Yes.
Lordship, this matter relates to the provincialization service of the petitioner. The respondents were to file their affidavit after seeking the instruction, but till date, no affidavit has been filed since 2018.
Rava?
update.
The matter was pending before Lozima Court matter. And for that matter, there was some delay. But we will file affidavit matter.
How much
2
time
weeks
is-
time may begin.
Okay, heard MS.
A. Bora.
A Bora Learning Council for the petition. On request made by Mr. Saraf, Leonard Standing Council,
PTC matter.
PTC, okay, Leonard Standing Council. How much time?
After vacation matter.
3 weeks time is allowed. You file
Lordship, kindly a date may be fixed.
Please after the puja vacation. No, after puja, I'm not fixing this.
Obliged, lordship.
6 and 7.
Lordship was directed me to produce this thing, interview papers. And it appears from our correspondences that entire papers are lying with the inspector of school. We have forwarded it on 23/6/2019, immediately after the interview was held. Thereafter, all the papers were forwarded.
When did you forward it?
It was on 23/6/2019.
23?
6/2019.
Then Sharma, you'll have to produce. Heard Mr. MP Sharma, Learning Council for the petition. Mr. D Nandi, isn't it?
Yeah, mine.
Learned Council for the respond number 5 subjects. That the entire reports of the selection of the principal of National Higher Secondary School, Plumding, has been forwarded to the office of the Inspector of Schools. Stop. Inspector of Schools, Lumding.
No, Nogang it is.
Now, huh? Stop. Para, Mr. U Sharma, the Standing Council. The Secretary Education Department shall accordingly produce the records of the selection of the principal of National Higher Secondary School Lumding in a silk cover. Please, after the puja village.
Should may kindly fix a date, Lordship.
I've already told you, I'm finding it difficult to fix it. You can make your mention if there's some urgency, and then we'll.
Deeply offensive.
Nice, Lordship.
Hey, please, Lord. Lordship, in this matter, senior counsel M.K. Sudri will appear, Lordship. Kindly take up after some time, Lordship. He is in leg. Just after some time.
All affidavits are filed?
Yes, Lordship is ready, Lord.
It's ready for hearing, Lordship. May otherwise fix it for hearing also.
No, Lordship, we have some urgency, Lordship. Senior counsel will appear, Lordship. It's 2019 matter, Lord. Fine.
May it please your lordship. Your lordship may kindly see the last order dated 19/9/2024.
Yes, higher education. You're directed to produce the show cause notice.
Probably lordship, lordship will fix after vacation, we'll produce it. Report not yet. Only case file is here. Lord. Immediately after vacation, we'll produce it, lordship.
Okay, heard MS SP Chowdhury and counsel for the petitioner. On request made by Mr. K. Goel, done it. Standing counsel, higher education. Is the matter of the Puja petition to enable him to produce the show cause notice as well as the reply made to the show cause by the petition.
Obliged.
10.
May it please your lordship. So in this case, lordship, we have to challenge the selection and appointment of the respondent number 8, lordship.
Who's appearing for respondent 8? You are free. Higher education? We are.
So next side.
And Fukan, you are for?
1 to 6, Milo.
NT,
1 to 6.
KK ND.
Okay. We have already filed affidavit in opposition, Milo. They have filed reply to that, Milo. And so the pleadings are complete.
Okay.
So a hearing date may be fixed, Milo.
That's it, 2020 meter, lordship. I'm praying that this meter will be disposed of on today itself, lordship, if possible, lordship.
Are you ready?
Milo, I'm ready, Milo. That is.
If
But
you want,
it
if
will
you-
take some time, Milo. You ready? Early hearing date may be fixed, Milo. That will be better, I think.
2020 meter, lordship. When
so when do you want?
Lord, within a week, Milord. Or
Next week
after
is not the,
immediately,
next week is the motion week.
immediately after vacation, Milord.
Can it be on 28, lordship, October?
After vacation.
What, Mr.
Our Fukan, lordship.
R. Fukan and the council.
Sure.
As well as Mr. PG Fukan,
29.
the standing council, KK Henry, state opening university.
29.
For the respondents, 1 to 6. Mr. S. Puyan, then the standing council higher education for the respondent number 7. And Mr. S. N. Barra, then the council for the respondent number 8. How about 10? These are performers. List the map. Go ahead. You want to have it on the admission hearing day, no?
Lordship.
Have it on 29th then.
29.
Obliged, lordship.
Help.
That was I think. Okay.
Wait, please, your lordship. As per the last order dated, that filed the affidavit. The only thing that needs to be verified, the query that fell from your lordship was that whether the termination order was served or not. And they have admitted in their affidavit that the termination order was never served. If I may draw your lordship's kind attention to their affidavit. Para 15, page 87.
Page
87. The affidavit which
Para 16, page 88.
yes.
that the Honorable Court wide order dated 10/6/2024 directed to place before this court record to show that the termination order in respect of the petitioner was served upon her, and also to clarify as to how the petitioner, who is stated to be an illegal appointee, was subsequently accommodated by order dated 31/2021. With regard to the point raised as to how the petitioner, who is stated to be an illegal appointee, was subsequently accommodated by order dated such and such, the answering deponent begs to submit that the entire process is narrated in the above paragraphs. However, with regard to the queries regarding serving of the termination order, it is to be submitted that as per the report of the Deputy Inspector School, show cause notice was issued to the petitioner on 33/1992, and he was later terminated from the service by order dated 18/5/1992. But there is no record of receipt of the termination order by the petitioners. It was also reported that the appointment filed for irregular appointee. So that's an admitted fact. Now, if that be the case that a termination order was never served, and para 6, your lordship, will come page 82.
Page
82.
yes.
That the answering respondent humbly begs to submit a state that on being appointed, initially the petitioner had received salary, though they were appointed dehoes the rules. However, due to shortage of budget allotted post, the salary of the petitioner was stopped since August 2007, as the petitioners are found to be irregular. So that's a contradiction being made by them. As your lordship is aware of the fact that irregular and illegal, there are two different concepts. So in that view of the matter, the Supreme Court has categorically laid down the law in very clear terms.
So the issue is in this part 6, this irregular. What do you mean by irregular? Is it the irregular appointment or a irregular in their service?
Your lordship will, for that purpose, my lord, there were two questions that was posed. My learned friend has read para 16, not the last part of the para 16.
1 minute. 1 minute.
He stopped. Your lordship takes a 10/6/2024 order, my lord.
Yes.
Person to this color, in terms of the, what was the situation for which the petitioner has been accommodated later, though he was found to be illegal and irregular, we could not find out whether it's illegal or irregular, because these people did not have the advertisement, the selection process, and therefore a opinion committee was constituted pursuant to a direction of this honorable court, my lord. May I just read, my lord, from para 4, my lord, the entire background. Your lordship, on the last occasion, allowed me to bring on record the background, which my lord will kindly find, my lord, from page 82 on para 6. Sorry, my lord, from para 5. May I just read? Page 81.
You can read from para 4.
Para 4. Yes. The petitioner instituted the aforesaid resolution praying for allowing him to continue working as a regular assistant teacher until retirement with all consequential benefit as per his appointment order dated so and so. to set aside the order dated so and so, whereby he was accommodated as a tutor with the condition that the accommodated tutor will get prospective effect from 1/11/2020, and he cannot claim benefit whatsoever in respect of past services rendered by him prior to 1/11/2020. The petitioner is also claiming for forthwith dispersal of his salary from September 2007 till 29 January 2021. The petitioner claimed to be appointed as an assistant teacher by the Deputy Inspector of Schools on so and so against a vacant post of earlier incumbent vacating the post on superannuation. Although the claim of the petitioner is that they were appointed pursuant to an interview, however, the petitioner have failed to substantiate the said claim by annexing any documents in support of genuineness of their advertisement selection towards the appointment. In fact, the petitioners were appointed without any selection process by the then Deputy Inspector of School against the non-existing post, divorced the rules. The answering respondent humbly begs to submit that on being appointed initially, the petitioners had received salary, though they were appointed divorced the rules. However, due to shortage of budget allotted posts, the salary of the petitioner was stopped since August 2007, as the petitioners were appointed found to be irregular. It is pertinent to mention herein that the petitioners as well as many teachers were appointed across the state during 89 and from 91 to 2001 without following government procedure against non-existent posts, which came to the notice of the government when it was detected that the number of incumbents were more than the total sanctioned budget allocated posts. That in the meanwhile, the issue of illegal irregular appointment of teachers across the state was under consideration of this honorable court in various writ proceedings. This honorable court in such writ proceedings directed the education department to take a call in the matter of regularization of irregular illegal teachers. Accordingly, in terms of order dated 2/3/2010, passed by this honorable court in WPC number so and so, the education department placed the matter of regularization of illegal irregular teachers before the cabinet in its meeting held on 26/2/2011. Thereafter, education department proposed to constitute a screening committee to examine the validity of the appointment of the teachers who are claiming regularization and salary. Accordingly, OM dated 15/11/2011, a screening committee was constituted to examine the cases of the illegally appointed teachers so as to take a decision for their regularization and entitlement salary or otherwise, with a view to examine the selection procedure, the nature of appointment, status of post, working status, status of salaries, academic qualification, etc. The Director of Elementary Education invited application from this illegal appointed teacher during the year 91/2001 throughout the state by an advertisement dated so and so in local newspaper. My lord will kindly note this, my lord. I'll come to this later. In person to the aforesaid advertisement for screening, applications were received from illegally appointed teachers throughout the state who were appointed during the year 1981 and 91 to 2001. After preliminary examination at the directorate level, total 12,085 numbers of applications were found in order and the same were submitted to the government for final verification. Thereafter, the Elementary Education Department by notification dated 4/6/2014 constituted 5 screening committees headed by Divisional Commissioner concerned and a Principal Secretary of 6 scheduled areas and BTC to examine the applications and the report of the preliminary committee. The said 5 screening committees were so and so. Thereafter, the Divisional Screening Committee verified all the applications and submitted a report with the recommendation views to the government for further action. However, due to complaints from various corners, the government directed for re-verification in respect of some districts. The respective screening committee, after causing re-verification, submitted their reports to the government. After verification of the reports of the Divisional Screening Committee, the following categories of teachers are identified. Category 1, recommended and working till date, number 136. Category 2, recommended but discontinued jobs, 250. Category 3, not recommended but working till date, 8,470. Category 4, not recommended and discontinued job, 2,900.
What is this?
Well, these are the numbers of the applicants.
No, recommended means recommended for regularization.
No, recommended by the selection committee, but there was no approval by the director in the select list. So though they were recommended, but the select list was not approved, but the appointment orders were issued.
Okay.
That pursuant to the report of the screening committee, a decision was taken to regularize the service of teachers who fall under category 1 and subsequently their services have been regularized. With regard to, well, these were the teachers which were actually irregular. The procedure was not followed, but there was a selection and advertisement. The category 1. and subsequently their services have been regularized. With regard to second category of teachers who were recommended but discontinued their jobs, the question of their regularization of the service and payment of salary does not arise since they are not in service. Similarly, in case of fourth category, since they have discontinued, consideration of their cases of regularization and payment of salary does not arise. In respect of third category of teachers who were not recommended but still in service, the state respondent had decided to issue individual so-called notices to all so-and-so, including 752 terminated teachers of Dhemaji and Lakhimpur. Malo, this petitioner belongs to that this 752 terminated teacher. Therein to show reason as to why their appointments are not deemed to be irregular as to why they should not be removed from service for being appointed in violation of the existing rule. However, in the meantime, the discussion was held between the Honorable Minister and the Teachers Association of Illegal Teachers. As per the decision of the meeting and as per suggestion of the Honorable Minister, the department had proposed to take a decision to solve the problem of this illegal appointed teacher, subject to approval of cabinet.
That is the category 3.
That is the category. Accordingly, a departmental committee was formed by the government to verify salary status and qualification of those category 3 irregular appointees. Thereafter, the committee has prepared 3 lists. List 1, the teachers who have received salaries at some point of time and having JBT DLL qualification. The numbers of teachers included in the list 1 is 1,574. List 2, the teachers who receive salary at some point of time but not having JBT DLL. List of numbers of teachers included in the list 2 is 2,960. List 3, the teachers who neither receive salary nor qualified the training. The number of teachers included in the list 3 is 7,250. The answering department is to submit that on the basis of the above list and after views of the department, it was decided to resolve the issue of irregular appointment by way of a preparation of a cabinet memorandum for placing it before the cabinet. Finally, the cabinet memorandum. Approval was sought for accommodating those teachers who have received salary up to 2007 and successfully completed junior basic training course by certain personnel supernumerary posts with prospective effect from the date of approval of the cabinet. Those posts will cease to exist as and when the incumbent returns from service. List 1 as teachers. Approval was sought for those who received 2000 salary up to 2007 but have not acquired professional qualification before 2011. Their job can only be accommodated as tutor with prospective effect from the date of approval of the cabinet. Now, this petitioner falls in this list 2. It is also pertinent to mention that one fact which the Lordship will kindly note this paragraph. It is also pertinent to mention one fact which petitioner has purposefully not disclosed, that the petitioner along with some other petitioner earlier approached this honorable court by way of WPC number so-and-so challenging an order dated 73/2007 issued by the DO, whereby it has been directed that the petitioner should be treated to have been not in service since termination with effect from 18/5/1992. The honorable court by the order dated so-and-so recused to interfere with the said order dated 17/3/2007 issued by the DO and considered the stand of the department, directed the respondent authority to submit the case of the petitioner to the screening committee for its examination and proper decision in the respect of salaries and status of appointment. The answering deponent begs to submit that the petitioner thereafter participated in the screening process by submitting their documents, and the aforementioned order passed by this honorable court, having now challenged or upon accepting the said order, the same has attained finality. Upon verification, the petitioner find place in category 3, not recommended but working till date as per the aforesaid cabinet decision. The petitioner who fulfills the aforesaid condition were offered press appointment with prospective effect from the date of cabinet decision according to their qualification. The appointment order issued to the petitioner with a condition that so-and-so will get the prospective effect from 1/11/2020 and only he or she cannot claim any benefit whatsoever in respect of past service rendered by him prior to 1/11/2020. The petitioner, having accepted their appointment of the said condition, is now stopped from claiming any benefit whatsoever in respect of the past service rendered by him prior to 1/11/2020. Now, I'm allowed to kindly take the writ petition for a moment. Paragraph 6 of the writ petition. The petitioner is claiming that they were never served with the termination notice, but they very well knew about this termination notice, firstly in 94 and thereafter in 2007 by an order that was issued by the DO, which was put to challenge. That was suppressed from this honorable court. Para 6, my lord, kindly. The petitioners, my lord finds para 6 of the repetition. The petitioner states that the petitioner was discharging his duties most sincerely with satisfaction of all concerned. After his appointment as assistant teacher, he has not received his salary for a long period. He approached the higher authorities for release of his legitimate salaries. The respondent authorities did not take any steps to redress his grievance. The next paragraph is very important. The petitioner stated that after receiving salaries up to 1992, on April 1994, the petitioner inquired in the office of the respondent number 4 why salaries from 92 and 94 has not been paid. The respondent number 4 informed the petitioner that he is entitled to salaries up to 92 as his service was terminated by the order dated 18/5/1992. It is to be mentioned herein that no termination order was issued to the petitioner. On 18/5/1992, this termination order was issued. It was known to the petitioner in 94. He never challenged. He challenged this. Now, my lord will find paragraph 8 for a moment, the first two lines. The petitioner states that the petitioner has received his regular salary with revised scale of pay up to 2007, but thereafter his salary was stopped without any reason. Now, my lord, the reason your lordship will find in page 90, my lord, the order of this honorable court.
Page?
Page 90. The order starts from page 91. my lord. The present petitioner is also one of the petitioner in this petition. May I read the order? Page 91. The writ petitioners are assistant teachers of LP school in the district of Dhemaji, Assam, and they have challenged in this writ petition the order dated 9/2/2007 issued by the government and order dated 7/3/2007 issued by the DO Dhemaji, whereby it has been directed that the petitioner should be treated to have not been in service since termination of their service on 18/5/1992.
1 minute. Okay.
18/5/1992. The same this date your lordship found at para 6 of the writ petition. The petitioner contended they were never served with any other order of termination of their service. The respondent, on the other hand, contended that in Dhemaji district, the teachers were appointed against non-sanctioned post, and because of this reason, the department concerned had to make inquiry into such illegal appointment and issue consequential orders of termination. In these circumstances, the respondent contended that the petitioners are not entitled to payment of their dues. For the purpose of determining entitlement of the persons, such as the present petitioner, a committee has already been constituted by order dated so-and-so. In terms of the direction given by the judgment and order dated 14/8/2003 passed by WPC number so-and-so and judgment and order dated 6/4/2006 passed in so-and-so. The term of reference of the committee are as follows. That at one particular point of time, large scale of anomalies had occurred in the matter of appointment of school teachers. Teachers were appointed against non-existence and fructitious posts, and in some cases, even the appointments were fake and manufactured documents. The dispute raised in earlier bunch of cases, 53 writ petitions, as referred by this honorable court in WPC number 2844 of 99 and other cases. In the present bunch of cases, 72 writ petitions would only require determination as to validity of the appointment made, but a further exercise is required to find out as to whether, notwithstanding the illegalities in the appointment, the person concerned has rendered service so as to decide their entitlement of school salary at least for a period for which service was rendered. The exercise will have to be taken would easily be fact-finding exercise, and the core facts would be necessary to decide the dispute. The consequential entitlement of the parties may require giving an opportunity of personal hearing. The committee will determine the reason for non-payment of salary stipend to each petitioner in present group cases. In that regard, if required, may also determine the validity of the appointment of the petitioner. The committee, irrespective of the question of validity of the appointment, shall also ascertain the period for which the petitioner has rendered service in the post to which were appointed, if any. The committee will hold its deliberation from time to time that such periodic interval as may be considered appropriate. The committee will also take up cases of such other petitioner which may be referred to it by this court in future. Though no specific time schedule is fixed, the committee will undoubtedly hold its deliberation and render its decision. Expeditiously will submit its finding to the state government for consequential action from time to time. The findings of the committee will be implemented by the state government in the education department by taking such further action as may be required in the event of the appointment of any petitioner is found to be illegal. The state government, if so advised, may proceed against such illegal appointee in accordance with the law. The terms and references as quoted above are applicable to case of the present nature too. This position, however, could not be assailed by the writ petitioner. In view of the above, the interest of justice, the writ petition is disposed with a direction to the respondent concerned to submit the case of the petitioner to the state committee for its examination and proper decision. The whole exercise so directed be completed within so and so. Well, this order has attained finality. And the issue with regard to the order of 2007 that their service has to be treated as a terminated with effect from 18/5/1992. That order has been not interfered by this honorable court. That order still remains. And that's not a challenge in this petition as well. Now, with regard to whether the termination order was served or not, we have said in paragraph 8. My learned friend has read half of the paragraph 18, my lord. Here we have contended, my lord, that we don't have the record of receipt of the termination order. But the second, this paragraph, the line starts from, it was also reported with very relevant. Why these records are not available with us? It was also reported that the appointment file for irregulars appointed against no sanction post in Dhemaji subdivision along with CR cases of irregular teachers appointed in the year 1989 were seized by one so and so inspector of police. CM Vigilance sends white Caesar list dated. However, in this context, it is relevant to mention the order dated 17/3/2007 issued by was very well known to the petitioner, and the same being not interfered, the continuation of the petitioner after 2007 will not confer any right for claiming salary, more so when the petitioner participated in the screening process and has accepted the appointment pursuant to the decision of the said committee. Now, my lord will kindly find the pursuant to the decision of the committee, which was approved by the cabinet, my lord, this appointment order was issued at page 53. Page 53. May I read it? In exercise of powers conferred upon the Director of Elementary Education by letter dated so and so, and in pursuance of the government approval communicated by so and so, and subject to satisfactory police verification and production of the physical certificate from the concerned Joint Director Health Service, the following candidate is hereby accommodated as a tutor in LP UP school on purely temporary basis in a fixed salary of 10,800 as per so and so, with concern of Dhemaji district with prospective effect from 1/11/2020. The appointment is purely temporary and is liable to be terminated without assigning any reason, and is, if any kind of fraudulence regarding the credentials submitted by the appointee established by at any point of time in future, the appointee will have to join his or listing within 15 days from this order. Now, my lord will kindly find down below, my lord. The post against which the appointee is accommodated as a tutor is purely personal in nature and will cease to exist as when the incumbent retires from the service or expires. This appointment is issued with concurrence of the finance and SIU department on so and so, which is communicated by letter dated so and so. My lord, kindly. The accommodated tutor will get prospective effect from 1/11/2020 only, and he or she cannot claim any benefit whatsoever in the past service rendered by him prior to 1/11/2020. And the petitioner has accepted this order, and therefore, my lord, the petitioner is paying for arrear salary up to 29 January 2011. That is prior to this order. After this order, he has received salary, the fixed pay which has been granted, and he is continuing. And
you are paying the current salary?
Current salary. We are paying the current salary. And the judgment, my lord, which the petitioner is relying at page 39 of this honorable court, where the petitioner also one of the petitioner in one repetition. It was a common order. This honorable court directed us to pay the salary since 2007. But these facts were never placed before the court by the petitioner, my lord. Even in this writ petition, my lord, this judgment, the order dated 9/5/2007 passed in WPC 164/2007 was not disclosed. And the issue which was raised in that order, my lord, page 91, that the termination order has not been issued. That argument has already been advanced in that petition, my lord. So now the petitioner, my lord, is stopped from making the same argument again in this petition. And that argument was rejected by this honorable court. Page 91. The first paragraph also clearly indicates, my lord, the petitioners contend that they were never served with any order of termination of their service. Page 91.
Yes.
My lord finds this line. Petitioner contends that they were never served with any order of termination of their service. So this, my lord, in my respectful sublimation, my lord, this issue is barred by res judicata. It was already
Was the petitioner,
he was a petitioner in this petition.
There is no dispute to that effect.
There is no dispute. He has not disputed.
in this writ petition, 1634.
Yes, your lordship, I'm not disputing that.
Okay.
That's all. Your lordship, the issue here is settled by the Honorable Supreme Court. It is an admitted fact on records and from the perusal of the earlier orders that the termination orders were never served upon us. Now, this order 1637, which my learned friend has just now read it.
1 minute. Termination order is dated
18/5/1992, they claim to be.
It is the
And my specific contention is that you have never served me with the termination order.
yes.
Now, in this case, which my friend has read just now, learned friend has read, that order, the Honorable Court does not say that when I made the submission that the termination order was never served upon me, the court does not conclude that no, the termination order was served upon you. In fact, it is the specific case. Your lordship will kindly look at page 94. I'll read first, second, third, fourth para. That, sir, has your lordship got it? That, sir, there is no such record of receipt of termination order by the petitioners. The appointment files for irregular teachers appointed against non-sanctioned post under Dhemaji division along with such of irregular teachers appointed in the year 1989 were seized by one Jagadish Sharma, Inspector of Police. Here also they are referring to irregular teachers, not illegal teachers. Now, the order which they have referred to in the writ petition wherein I was appointed as a tutor, that was issued way back in 2021. In my respectful submission, that order is per inquirium. If your lordships kindly look at page 53.
Yes.
This order appointing me as a tutor, I would say this order is per inquirium.
How?
Yes, your lordship. Dulu Devi. This was the case which traveled till Supreme Court, your lordship. This was Dhemaji district with respect to the appointment by the Dhemaji district. Para 3, I'll start from para 3, your lordship. The appellant was appointed as assistant teachers in Assamese subject in Dhemaji Hindi Lower Primary School in 1976 by an order dated 19/12/1989 of the Deputy Inspector of School Dhemaji the appellant was finally appointed as an assistant teacher as against the substantive vacancy in the said school. Even though the appellant was rendering continuous service of assistant teacher for more than 10 years, she was not paid her salary. Aggrieved by the same, she filed writ petition dated such and such. Thereafter, the respondent authority directed the Deputy Inspector of School Dhemaji to inquire into the non-payment of salary and furnish a report. On submission of such report, the Additional Secretary Education Department wide dated such and such directed the Deputy Inspector of School Dhemaji to release the salary of the appellant for the period she had rendered her services. Thereafter, by order dated such and such, the High Court disposed of the said petition with the direction to the respondents to release the salary of the appellant not only for the current month but also for the period she actually rendered service as a teacher, and to make an inquiry as to the appellant's entitlement for regularization of her services and pass necessary orders. It is stated that the respondents have not filed any appeal against the said order, and therefore the findings of the direction of the apostated had since attained finality. In view of the direction by the High Court, wide order dated such and such, passed in such and such, the appellant was paid all the area salary and allowances till August 2007. That is similar to that of the petitioner. Now I'll skip that. I'll come to para 8, your lordship. Next page, 624. The findings. Has your lordship got it?
Yeah.
We have heard the learned counsel appearing for the parties and peruse the records. The learned counsel appearing for the appellant submits that appellant had never been terminated from a service and that no order of termination had been ever served upon her. This was the issue before the Honorable Supreme Court. He further submits that without going through the relevant records and files, the respondent authority prepared a list of 193 teachers and included the name of the appellant for terminating their services. Indisputably, the appellant had been paid salary by the respondent authorities for at least 25 years without serving any termination letter upon her. The learned counsel appearing for the respondent contends that the appointment of the appellant is itself illegal on the ground that she had underage at the time of her appointment. He further contends that as the appellant was appointed in a non-existent post, she did not get her salary till July 2007. The learned counsel appearing for the respondent submits that the respondent authority terminated the service of the illegally appointed teachers, including the appellant, but they are continuing in service and drawing the salary till 2007. However, their salary was stopped with effect from August 2007. Thus, the appellant's salary was also stopped and she was appointed illegally and her service was terminated in 1992. He further submits that the High Court has rightly held that if the services of the appellant stood terminated in the year 1992, then she has no legal right to claim salary, regularization, and promotion of service as relevant materials were not produced before it when the earlier order was passed by the High Court, directing the respondents to release the salary and allowances to the appellant and also to make an inquiry with regard to the claim of the appellant for regularization. We bestow our anxious consideration to the rival submission made by the learned counsel appearing for the parties and find substance in the submission made by the learned counsel appearing for the appellant. Indisputably, the appellant has been continuously serving as a teacher since 1989, and pursuant to the order passed in the earlier petition, the appellant was paid entire salary since the date when salary was not paid. The High Court took notice of the fact that while considering the regularization of the appellant, she being the senior-most teacher of the school was allowed to cross the efficiency bar 2 times. Initially, the year 2003 and subsequently in the year 2005. The High Court in its impugn order noted that the letter of termination order was neither issued nor were the services of the appellant terminated. Admittedly, some of the terminated teachers filed their writ petition challenging the termination, which was interfered with by the High Court, but the court observed that the said benefit cannot be granted to the appellant as she was not a party in the said writ petition. The High Court, assuming that the services of the appellant were terminated, refused to grant relief and dismiss the writ petition. This was the observation of the Honorable High Court. In our considered opinion, the approach of the High Court is not in accordance with law. The service of the teachers who have been working for last 25 years shall not be assumed to have been terminated and deprived of our legitimate claims. The Constitution Bench of this court in state of Punjab and such considered this aspect of the matter. Writing this judgment, his lordship such and such held that mere passing of an order of dismissal or termination would not be effective unless it is published and communicated to the officer concerned. If the appointing authority passes an order of dismissal but does not communicate it to the officer concerned, theoretically, it is not possible that unlike in case of judicial order pronounced in the court, the order may change its mind and decide to modify its order. The order of dismissal passed by the appropriate authority and kept with itself cannot be said to take effect unless the officer concerned knows about the said order and it is otherwise communicated to all the parties concerned. If it is held that mere passing of an order of dismissal has the effect of terminating the services of the officer concerned, various complications may arise. Similar view has been taken by this court in Union of India and Dinanath such and such, wherein the services are terminated, the status of delinquent as a government service comes to an end, and nothing further remains to be done in the matter. But if the order is passed and merely kept in the file, it would not be treated to be an order of terminating, nor shall the order be deemed to have been communicated. In the background of the facts of the said case, particularly the service and such, the impugn order passed by the High Court cannot sustain in law. For the aforesaid reason, the appeal is allowed and the impugn order is set aside. Consequently, the appellant shall be entitled to continue in service and further entitled to all areas of salary in accordance with law. So, Your Lordship, this court has held one thing in very categorical terms. The Honorable Supreme Court, as well as the Constitution Bench of the Honorable Supreme Court, it has categorically stated, fine, you have terminated me, no issue. But you have to submit the termination order.
Yeah, that part of the termination order, that is one thing.
Yes.
But this petitioner in this particular case,
Yes, Your Lordship.
he or she was appointed to a substantive vacancy,
Yes, Your Lordship.
correct?
Yes, Your Lordship. Your Lordship, the core issue which was here in this case is that rightly or wrongly you have terminated me as claimed by you, whatever be the case. You have not issued me the termination orders. So once you have not issued me the termination orders, I'll be deemed to be in service. That's what it's stated. So you say that I am illegally, sometimes you say I'm irregular, fine. You have every right to say everything. But that has to be done in a, yeah, Lordship, it is a service matter. In the service matter, we are not challenging the decision. We are challenging the decision-making process. It is ultimately the procedure which has to be looked into. That's what the Honorable Supreme Court has stated, Your Lordship. That you have terminated, it's their own case that I was not served with the termination orders. Nowhere in the judicial order it is reflected that I was terminated and I was served with the termination order. Right throughout until date, it is my case that I was never served with the termination order. That was a similar appointee. So the procedure which requires to be followed and the law laid down in following those procedure has not been followed. It is your own case. In fact, the Honorable Court has stated in the last order, Justice Nair has passed an order. Your Lordship has gone through it. That you show something on record that the termination order has been served, which they have failed to show. And as regards, they have said that I have not challenged anything. I have not said all those things. This has attained finality. Has they challenged? Has they gone on appeal? Or has they filed a review against those orders? No, till date, they have not filed any review. It is only by this affidavit they have improved their case, which in my humble submission, they cannot. As clearly stated in Mohinder Singh Gill and Govardhan Das Banji, that you cannot improve your case by an affidavit. You have not served me the termination order and you are saying that this has happened, that has happened. Nothing has been suppressed before an honorable court. Everything is on record. My specific case is only on one point, that you have never submitted termination order, right from day one to till date. And in fact, Honorable Justice Michael Zothanguma sitting in court number 4 has also observed that. And you have not gone in an appeal in that case. If that be the case, you should have filed an appeal in the Dulu Devi's case. And you have not considered that case also. And the judgment of the Constitution Bench followed by, I'd like to place this to Your Lordship. Year 1966, 1313. Your Lordship is holding this judgment year 1966.
1 minute. Yes.
Para 11, Your Lordship will come to fourth page, I'm sorry. Para 11.
Yes.
Has your lordship got it? The first question which has been raised before us by Mr. Bishan Narayan is that though the respondents came to know about the order of his dismissal for the first time on 28th May 1951, the said order must be deemed to have been taken effect as from 3rd June 1949, when it was actually passed. The High Court has rejected his contention, but Mr. Bishan Narayan contends that the view taken by the High Court is erroneous in law. We are not impressed by Mr. Bishan Narayan's argument. It is plain that mere passing of an order of dismissal would not be effective unless it is published and communicated to the officer concerned. Your Lordship, this judgment is narrowed down its finding to only to that aspect that the termination order, dismissal order has to be communicated and published.
Yes.
If the appointing of the passes an order of dismissal but does not communicate as to the officer concerned, theoretically it is possible that unlike in the case of judicial order pronounced by the court, the authority may change its mind and decide to modify the order. It may be that in some cases the authority may feel that the end of justice would be met by demoting the officer concerned rather than dismissing him. An order of dismissal passed by the authority, appropriate authority, and kept it itself cannot be said to take effect unless the officer concerned knows about the said order and it is otherwise communicated to all the parties concerned. If it is held that the mere passing of the order of dismissal has the effect of terminating the service of the officer concerned, various complications may arise. If before receiving the order of dismissal, the officer has exercised his power and jurisdiction to take the decision or do acts within his authority and power, would those acts and decision be rendered invalid after it is known that an order of dismissal had already been passed against him? So this was the finding of the Constitution Bench, Your Lordship, which was relied upon in Dulu Devi by the Honorable Supreme Court. So the core issue is that when you passes a termination order, you have every right to do so, being an employer. Rightly or wrongly, you may do it. The decision-making process will be challenged before this honorable court. But have you followed the procedure laid down by the court? And the last, Your Lordship, the judgment 1998 7 SCC 569, para 9, Your Lordship.
19.
The other judgment I've given, Your Lordship, 1998 7 SCC 569, para 9. Has the Lordship got it?
Yes.
Where the services are terminated, the status of the delinquent as a government servant comes to an end and nothing further remains to be done in the matter. But if the order is passed and merely kept in the file, it would not be treated to be an order terminating the services, nor shall be said order to be deemed to have been communicated. So in my humble submission, Your Lordship, this petitioner was never terminated. Assuming that the petitioner was terminated, this petitioner was never served with the termination order. And in that view of the matter, I am entitled to my salary, which this honorable court has also passed in one of the case, Lucky Prabha Borua. I'll just hand over that.
You are claiming your salary from
2007, Your Lordship.
2007.
2007. September 2007.
Up to
Till the current salary, Your Lordship, because the termination order has never been handed over to me.
till the date of passing that order, accommodating as
Yes, Your Lordship.
tutor.
There is no quarrel to that effect what my learned friend has submitted, except to the fact that some facts has not been placed. Every fact has been placed before this court. And those have no material bearing. There is not even a single judicial order which shows that the court has concluded that I was terminated and served with the termination order. Let him show single order on that issue.
Yes.
So in my humble submission, Your Lordship, this petition is to be allowed, directing
This is what? WBC?
This is WPC 3979 of 2017, Your Lordship. I'll straightway come to para 16. Dulu Devi has been referred here, page 6. Para 16, yes, the Lordship got it?
On
Internal page 6.
okay.
Be it stated that in case of Dulu Devi versus State of Assam, which also related to service in LP school in Dhemaji district, I am also from Dhemaji district. Supreme Court, referring to the earlier constitution bench in state of Punjab and such, held that mere passing of an order of dismissal or termination would not be effective unless it is published, communicated to the officer concerned. I will not read the other portion. Number 17. In the instant case, the petitioners were appointed in 1989, just like me. They have been rendering their services for 20 years now. As a matter of fact, their paid salary up to July 2007. That is for a period of 18 years. Continuance of service by the petitioner is not disputed as per the admitted stand of the respondents. No termination order has been issued to the petitioners. In such circumstances, withholding of salary of the petitioner would not be justified. Consequently, impugned order dated such and such is set aside and quashed. Respondents are redirected to release the area salary of the petitioner with effect from August 2007 within a period of such and such time. So that view has been taken by the coordinate bench also, Your Lordship. If at all they are aggrieved, they need to file a review petition in Dulu Devi's case, Your Lordship. And all these orders which has been passed by Honorable Court, Honorable Justice sitting at court number 4, court number 17, and in the earlier round of litigation, this has not been challenged. And the order which my learned friend has referred to, that I have not referred the judgment, that never says that I am not agreeing with your statement. That the finding of the court in that judgment was that they will form a committee, the committee will examine. The court, in fact, did not conclude that I was terminated or served with the termination order. The court simply dispatched the matters to the committee constituted by it.
All right.
So that's just one point. This 2007, they are claiming salary from 2007. And the order of termination was of 1992. Subsequently, this order of termination was communicated by order dated 17/3/2007. That is page 91. That was the subject matter of challenge in that application. 163. My lord, kindly mark this order, my lord. The challenge in that repetition was order dated 7/3/2007, issued by the
Yes, which order?
page 91. The first paragraph of the judgment, my lord. Your lordship has seen that this is by this order, they were communicated that their service is not to be treated with effect from 18/5/1992. Here, my lord, the government is not claiming any recovery of the salary from 92 to 2007. His salary was stopped pursuant to this order, and this honorable court refused from interfering with this order.
I just
Dulu Devi, my lord,
sorry.
the distinguishable fact is Dulu Devi was in a substantial post, my lord. My lord, I'll rely on a judgment of the Honorable Apex Court. I'll place the judgment, my lord. 2020 15 SCC 466, my lord. State of Bihar versus Devendra Singh.
2020.
15 SCC 466. Para 36 and 44 of that judgment.
Who is that?
State of Bihar versus Devendra Singh. I'll give a copy, my lord.
Oh, you don't have copy now.
I have just.
Okay.
Your Lordship.
There, my lord, Supreme Court says once the appointment is illegal, my lord, they are not entitled for anything, including salary. The word is used like.
Your Lordship, I am not on that part whether I am illegal or irregular. In fact, they are also confusing. Page 93, they have stated, that paragraph I have read, that they have stated to be irregular, my appointment. And in this case, they are relying on an order dated 17/3/2017, issued by the Director of Elementary Education, saying that I should not be considered in service because I was terminated. That was not the termination order. That was a subsequent order passed by the DEO saying that these people should not be treated to be in service because they were terminated by such and such order. So where is that order? Let him not confuse the court. Let it be plain and simple. The issue is the termination order has not been served.
Okay.
That was never done. So Dulu Devi relied on a judgment passed by the Constitution Bench of the Honorable Supreme Court, wherein it said that the termination order cannot be kept in file, it has to be served to the person and communicated, which was not done. That's an admitted fact on record, Your Lordship. Yes, they've said it that we have not served the termination order.
Not para 18, we say
Let me
that
complete
it
it.
was
Let me complete.
I've gone through.
para 18, it was issued. We don't have the receipt of the record
That's it.
because it's
What's
seized
more
by the
required, Your
police.
Lordship? Service law is all about the procedure that has been followed or not.
And repetitioner also in para 6 says that he knows about it in 94 itself.
But Mr.
Arsena.
Arsena and then also heard Mr. B. Coffee, understanding of elementary education.
Standing of elementary.
For the respondents,
All respondents.
one, how about 5?
5. There is no 5 in the.
Yes, 5. Board of Secondary Education.
No, 4, 5 karva korisile sage.
Possibly later on.
Later on, perhaps it was impleted, Your Lordship.
Ah.
He can implement.
No, I cannot.
No, he
DC
can-
Suti appears for.
Where's this is Chitia?
Government of bonus is party. Seba kyo ba bonus is naga no ito. Anyway, there is no fight with that Seba, Your Lordship.
By order of 2/1/2023.
23, yes, sir.
Seva, but then at least Seva Council was.
Oh, you need to inform him, Malot. We'll inform him, Malot.
No, he may have something to say.
Possibly the issue which relates Malot Sepa.
No, but then this court on 2/1/2023, Justice Pathak has passed the order.
Maybe, Your Lordship, because there was some point raised against, maybe because of
I
some, but
remember correctly,
there is no, otherwise there is no grievance or no quarrel with the Seba, Your Lordship.
Anyway. Okay, can you inform him?
Yes, sir.
I'll fix a short date, and then he, in his presence, I'll discuss. Another case. What is one of the 5 public? Is Seba, isn't that secondary education?
Yes, Your Lordship.
Yes,
Seba. What's the matter? Again, when do you want?
I think Your Lordship has heard the matter considerably. A short date.
It will be on Thursday, Malot. Okay.
On 26 as part of.
Deeply obliged, Your Lordship.
Careful. I'll give the copy of the judgment.
Yeah,
13.
Let me please, Your Lordship. Your Lordship, as per the previous orders, Your Lordship, today the matter was supposed to be disposed after the instructions were obtained by the other party, Your Lordship.
yes. Yes, I can have you received.
My lord, initially pension proposal that is submitted in 2022. Some document was not enclosed accordingly. Pension department has remanded to the inspector of school, my lord. Subsequently, my lord, inspector of school has said that asking the original service book, my lord. As per my instruction, that is not recorded in the director. That is in the inspector of school itself. Today they have replied the letter also.
Your mic is on.
Yes, ma'am.
Yes.
My lord, discussion.
If I may take your lordship to page number 58, your lordship, of the running page 58, paragraph number 4, your lordship. Your lordship, in the last part of the thing, they themselves have actually quoted for issuing of non-liability certificate, your lordship. Page number 58, the last, after the last full stop. The fifth last line, your lordship. For issuing the non-liability certificate by a DDO, the period has to be cleared by the audit department first, and therefore the DDO can issue the non-liability certificate. The deponent has no problem to settle the pension of the petitioner, but if the authorities of the department clarifies the designation status of the petitioner on the date of his retirement. Your lordship, they have said that. Plus, on the next page, your lordship, they have contradicted themselves, your lordship. Page number 59, your lordship. From the third line, that paragraph, your lordship, or in the event the petitioner gives an undertaking that he is ready to accept the final pension in the PGT scale of pay, the deponent would process the same immediately after adjusting the amount received by him as in excess of the principal. Your lordship, they're contradicting themselves, your lordship, in this matter. Your lordship, and
Where is your instruction?
there is no instruction regarding that, your lordship.
My lord, by instruction in regards to the original service book only. Regarding the scale and all, that will be looked after by the concerned state department. In the service book, my lord, original service book that has returned, my lord, on 6/1/2022, my lord.
No, who is the concerned department?
Concerned department, education department, second department.
Lordship, my instruction is that, Lordship, the provisional pension and everything had been given, only the final pension has not been given, your lordship.
What's the issue?
Your lordship, may I present out? Since the past 4 months, they have stopped our provisional pension also. We have not received 1 rupee from as a provident pension. That instruction is my learned friend has obtained is wrong.
Lordship,
When did they stop?
They stopped since January, your lordship. Not January, February. Your lordship, may I just confirm? July, since July, your lordship. The past 3 months, they have not.
Lordship,
June, July, August, and then subsequently September.
because Lordship, initially he was promoted as a principal. Then after that, he was again brought back to the post of teacher, assistant teacher, your lordship. So that has to be calculated, your lordship. And that proposal has to come from the principal. And my verbal instruction is that.
Principal has already filed in September.
Lordship, he has filed, but we had been communicating with him and he is not giving us the proposal, your lordship.
Which proposal?
The proposal for the pension, your lordship, pension, and also after calculation of everything, your lordship, the MSCPS and everything.
The GKF has been,
Yes,
your lordship, that the process, your lordship, whatever the exercise is, it should be completed within so and so time, your lordship, because from the past 1.5 years, your lordship, they are dilly and dallying in this manner, your lordship.
Non-liability certificate.
Your lordship, this
has
is
to be given.
clearly a power trip, your lordship. In page number 59, if you see, your lordship, I may read that. An effort has been made to settle the issue of pension of the petitioner after taking his undertaking in the presence of the SMDC of the school. But the settlement process has failed due to non-cooperation on the part of the petitioner for unknown reason. They have no document that needs to be collected from me, your lordship. This is just a power trip that has been played, your lordship. The exercise may be completed within so and so time, your lordship.
Issue is that, my lord, he was getting the provisional pension at the scale of principal, my lord. When my lord, his principal post has gone, my lord. And now he has pension has to be recalculated at the scale of postgraduate teacher. And in that regard, the principal being the DDO, he has already intimated the inspector and director, my lord, but no further instruction has not come to the principal with regard to the mode of calculation, whether it should be in the scale of PGT or in the scale of principal. He has written the communication, my lord. Now the settled position is that he has retired as a subject teacher. Your lordship will dispose of the writ petition with the direction to settle his pension as a subject teacher. That's all.
Your lordship, within a time frame, your lordship. But
Yes,
time
that
frame, 30 days, your lordship, they may do it within 30
and
days.
non-liability will be issued, my lord, by the subject to the calculation
what are the excess amount he has taken,
Okay,
that will
heard
be done.
Mr.
AM Barwa, Your Lordship.
K.N. Barwa.
AM.
A.M. Barwa.
AM Barwa.
Learned counsel for the.
2019. 39.
Also heard MS Mushari, you agree? T. Mushari. Learned standing counsel, secondary education report. For the respondents, 1, 2, 3. 1, 2, and 3. Public pension, Mr. B. Saika. Learned standing counsel, learned governor. Appears for respond number 4. Finance, MS RM Barwa, learned standing counsel finance, appears for respond number 5. MS. Okay, Mr. C. Barwa, learned standing counsel, accountant general for respond number 6. And Mr. B. Purgasta, learned standing learned counsel for the respond number 6.
7.
7. Stop. The petitioner was initially appointed as a subject teacher in zoology in the Makibaha Higher Secondary School by an order dated 25/11. No, by an order
22
dated
to
22 to
1985.
1985. Well, that order is not there.
Your Lordship. Order to authorize person appointment order.
Your appointment order is not there.
Indeed, Your Lordship. We have not attached the appointment order.
By an order dated 22 to 1985. To which post?
As a
He joined
subject
on
teacher.
1/3/1985. Stop. Draft report. After serving for a period of 1 year, the petitioner was transferred to the Karara Higher Secondary School by an order dated 25/1986. Stop. In the meantime, the who issued the advertisement? Oh,
It was by the school concern, my lord. At that time, school concern, school selection committee.
the principal, Karara Higher Secondary School issued an advertisement for appointment of regular principal. Stop. The petitioner accordingly applied for the said post in terms of the advertisement. And after going the regular selection process, the petitioner was appointed as principal on regular basis and posted in the Karara Higher Secondary School, District R, by an order dated 2nd May 2017, issued by the Director of Secondary Education. Stop. Para. The appointment of the petitioner as principal of Karara Higher Secondary School was challenged by one Pratik Kumar Goswami by filing WBC number 2631/2017, which was disposed of by an order dated 13/6/2019, wherein this court interfered with the appointment of the petitioner as principal. By the order dated 2/3/2017. No, 2/5, isn't it? 2/5. Come to page 34. Here, the third line from the book of para, the third line from the bottom of para 32.
Regard as appointing to 2/3/2017 appointing of the sets.
Date is wrong, Malad.
Date is wrong.
Date is long, your lordship.
It's
The
correct
order-
is 2/5/2000.
Order dated
In the subsequent,
2017. By which the petitioner was appointed as the principal of Carrara Higher Secondary School was set aside in post. So. Accordingly, the petitioner was reverted back to the post of.
No, my lord. In the meantime, he has preferred a read appeal.
Read appeal, your lord.
Read appeal, my lord,
At page number 35.
35, my lord.
Sufferer. Being agreed with the order dated 13/6/2019. Passed by this court in WBC number 2631 of 2017. The petitioner preferred a writ appeal being WA 172 of 2019, which was disposed of by order dated 11/12/2019, whereby the appeal filed by the petitioner was dismissed. According to PAR, the petitioner was reverted back.
No, he was, my lord, by this time he retired on 30.
No, after his reversion
Did, your
only,
lordship. This
he retired.
No, he retired earlier.
Okay, yeah, yeah.
superannuation happened for
In the meantime, pending the disposal of the writ appeal.
Yeah.
The petitioner retired from service.
On 39/2019.
39/2019.
30, sir. 39, your lordship. 39, 2019.
On 39. No. Stop the number later. The grievance of the petitioner in the present writ petition is that the pensionary benefits and other related, the pension and other pensionary benefits has not been granted to the petitioner, despite retiring on 39,000. Stop. But the respondent number 7 has filed affidavit of compensation. And Mr. B. Purkas, learned counsel appearing on behalf of the respondent number 7, submits that the respondent number 7 has written a letter dated 13/6/2023 to the inspector of KDC Amingao, followed by another letter dated 22/6/2023 to the Director of Secondary Education, Assam, seeking clarification with regard to the refixation of the salary of the petition staff. He submits that for issuing the non-liability certificate by DTO, the period to be cleared by the audit department. And thereafter, the period has to be cleared by the audit department. And only thereafter, the DTO can issue the non-liability certificate. Stop. He further submits that the respondent number 7 is willing to settle the pension of the petitioner only after the authorities of the department clarifies the status of the petitioner on the date of his retirement. Stop. Para. Responding to the submission made by the learned counsel for the respondent number 7, Mr. A.M. Barwa, learned counsel for the petitioner, submits that the petitioner is seeking for his pensioner benefits on the basis on the status of a subject teacher, in as much as his appointment as principal of the Karara Higher Secondary School has already been interfered with by this court. And therefore, there is no impediment on the part of the respondents to process the pension papers of the petition in the status of the subject staff. Recording the submissions made by the learned counsel for the petition. This petition is accordingly disposed of, directing the respondent number 7 oblique the principal who's the 7?
The principal of the Corona Higher Secondary School.
Principal Karara High School,
Higher Secondary School.
Higher Secondary School, to forthwith process the pension papers in respect of the petitioner in the status of subject in the status of the subject teacher of the said school. Stop. Let such steps be taken and completed within a period of 2 weeks. 2 weeks from the date of receipt of a copy of the order of this stuff. Thereafter, on receipt of the pension papers of the petitioner from the respondent number 7, who will be the next authority?
Next, the IS will be my lord, next. And thereafter the director of pension.
Inspector of schools.
Inspector of schools will go to director.
Before the inspector of schools, KTC, stop. Thereafter, the respondent oblique respondent number 3, within a period of 2 weeks from the date of receipt of a copy of the order of this cost. Thereafter, the respondent number 3 shall take steps for forwarding the pension papers to the concerned authorities for finalizing the pension of the petitioner within a period of 2 weeks on receipt of the pension papers from the respondent number 7. Stop. The whole process for payment of pension to the petitioner thereafter should be completed within a period of 2 months.
2 months.
60 days. Within a period of 2 months from the date of receipt of the pension papers from the respondent number 3.
My lord, access and royal has to be.
Your lordship, that is a
adjusted.
subject matter of different,
That is a different thing.
subject matter of different.
I'm not.
Pension benefit and benefit includes DPF also, we have already paid that.
Indeed.
On top, just say Mr. C. Barwal and Standing Council Accountant General Assam submits that the TPF amount amounting to rupees, give me your.
Last paragraph, Mr.
Amounting to rupees 10,35,705 has already been paid.
Date also is given.
By letter dated
We acknowledge the fact.
9/12/2020.
Much obliged, your lordship.
Starts from page 10, para 8 to para 9, my lord. Lord, I applied on time, my lord. Within 1 month, my lord, I applied. But
Okay,
it
let
was
it
rejected.
come, take up
My lord.
after some time.
I have another prayer, my lord. If your lordship, my lord, allow me, my lord. In item 33, my lord, the last part item, my lord. That is, my lord, that may come after vacation. I have taken the consent from the respondent, my lord. He was all along there, my lord.
Okay,
Item
item
33.
request made by Mr. Zed Ahmad, list the matter after the.
My lord. I'm deeply obliged.
After the. Yeah.
Right.
Item 14.
But I have got the instruction that my lord,
Lordship, the petitioner has been appointed as in charge headmaster, your lordship. This is the
lordship may
order, your
record that and dispose of it.
This is the order, your lordship. We have also filed our affidavit.
Yeah, Patik Baro.
Yes, yes.
Okay, MSD Mushari. Learned Standing Council Secretary, Education Department. Has furnished an order dated 30/4/2024. Issued by the Director of Secondary Education of South. Whereby the petitioner has been temporarily allowed to act as headmaster in charge of Balijan Girls High School.
Yes.
District Sunitpur. Stop. Mr. B. Burgasta, Leonard Council for the petition submits that that as the petitioner has been appointed, has been allowed to act as headmaster in charge of the Balijan Girls High School. You want to close the writ petition?
Yes.
The writ petition will be closed. Accordingly, writ petition is disposed of. The order dated 30/4/2024 is placed on the court.
Obliged.
Obliged, sir.
8.
May please, your lordship.
My lord, the petitions are claiming regulation in their service as lecturer in a college in my lord Kirby Anglong. They have been working, they are working since 2001. Initially, they were appointed on 3F, and subsequently that service was terminated. But then, my lord, the court, this honorable court set aside their termination and they were reinstated in service. They are continuing. Now,
You continue on the basis of the order of 3F.
initially, my lord, the appointment was under 3F.
Oh.
Then, my lord, they appeared in the APSC examination. They, my lord, got through it, but their names were far below. Then their services were terminated. Then they approached this honorable court, and my lord, by virtue of this honorable court's order, they were, my lord, reinstated in service. Then, my lord, they were appointed on contractual basis. So, on contractual basis, they are continuing till date, and the last order has been passed by extending their service with effect from 1st of March 2023 for 5 years. Now, my lord, the issue that calls for consideration of your lordship are two, my lord. Firstly, all other, my lord, college teachers like these petitioners in my lord Kirby Anglong, they have been, my lord, regularized in service, and for reasons which, my lord, I can show from the records that, my lord, their names were left out. Other persons have been regularized. And there are, my lord, two affidavits, in fact, three affidavits, one filed by the Principal Secretary of the NC Hills Autonomous Council, and another by the Director, Secretary, Higher Education Department, and another additional affidavit filed by the, my lord, the Principal Secretary of the Autonomous Council. May I take your lordship's kind attention to order dated 19/1/2024.
Yes.
May I read that, my lord? On the heart so-and-so, on the prayer of so-and-so, the NCL automatically released this matter again on 13/2. On the next date fixed, Mr. Sharma, with reference to the contentions made in paragraph 7 of the additional affidavit filed by the Principal Secretary, Northcastle Hills Autonomous Council, Haflong, in the present proceeding, shall apprise this court the extent of power of the said council with regard to the delegated subjects, more specifically the college education. The competent authority of the said council shall also apprise this court as to the extent of power exercised by the council with regard to functioning of the Haflong Government College. The said instruction be produced before this court in a written form. Now, my lord, for that, my lord, may I take your lordship to the additional affidavit of the Principal Secretary, because, my lord, paragraph 7 of that affidavit additional affidavit has been filed on 23rd of November 2022. It will be, my lord, starts at page 101.
113.
101 is the, my lord, additional affidavit. 101.
Here it is 113.
103.
113. Anyway.
Paragraph 7, has your lordship got it?
Yes.
That the deponent begs to state that as per office memorandum issued by the government of Assam in the Hills Area Development Department, wide notification dated 31/12/1996 and number such and such dated 25/5/1996, and Education Department, Government of Assam's notification number such and such dated 15/2/2005, the Department of Education has been brought under the administrative control of North Kasar Hills Autonomous Council. Thus, the North Kasar Hills Autonomous Council is empowered to issue such appointment and engagement order. Now, that instruction, my lord, my learned friend will produce. Now, may I take your lordship to the, my lord, basic facts of the writ petition? Why, my lord?
Before you go, let us see this OM 31/12/1996.
No, this OM are not there, my lord. This was the stand of the, my lord,
Okay, all right.
secretary, and thereafter, my lord, on that basis, my lord, it was directed that the
You have the OM?
Lordship, I have the notification, Lordship, but it's not clear, Lordship.
Direction was to, my lord, produce it in the, my lord.
Form of you are supposed to, by way of a written form.
Yes, Lordship.
Have you read the order of 19/120?
Yes, Lordship. Lordship, here I submit that higher education is not a transfer subject. Lordship. Higher education is not a transfer subject. And the petitioners, we had recommended for regularization her name, but her regularization was cancelled because she did not have appropriate qualification, Lordship.
No, my lord, let him produce the instruction, my lord.
Para 7, I am on para 7 of your additional affidavit. The OM dated 31/12/96 and the notification dated 15/2/2005.
If he doesn't have that, my lord, let him produce it. I can wait for a few days, my lord, no issue with
Lordship,
that.
I have. It's just a focus more.
And the notification?
Earlier case, Lordship.
Have you finished your copy?
No, Lordship. I'll finish it.
Thereafter, my lord, the matter came on 12/9/2024. And my learned friend, he asked for some time. He said that he received the relevant records and yet to go through the same, as such he prays for a short accommodation.
Yes.
I have the records.
Have you produced a copy? You have.
No, my lord.
Yeah.
So we'll give it to.
Let him give it to me, my lord. Let it come day after tomorrow, my lord. Yeah, I can also go through so that my lord time is saved.
Okay.
Then Lordship.
Tomorrow, see, some difficult with my part. Need it, after tomorrow, after tomorrow, okay, at least 8 pattern methods is there.
Let him take his convenient date, my lord. I have no issues with that.
You give your date then.
Otherwise, no, see, immediately after vacation also, no, see. Next week is miscellaneous week, declared by this court.
It's my lord 2019 matter. Let us try before the holidays, my lord. If time permits, fine. Otherwise, my lord.
I have no issue, Lord. Otherwise, Honorable Registrar declared is a miscellaneous.
Yeah, next week is a
Miscellaneous.
motion week.
Yes. Then your lordship will fix a date, my lord, after the vacation. Immediate.
But M.K. Chowdhury, Learned Senior Counsel, Assistant Prime Minister,
AU1.
AU Ahmed, Learned Counsel. Stop. On request made by Mr. K. Google, Learned Standing Counsel, Higher Education Department. Please the matter on 29th, 21st,
My lord.
29th of October.
Yes, my lord. That
The
is.
hearing date.
My lord, let it be recorded. My lord, either he gives me a copy, my lord, or he files an affidavit.
Don't say on request, sir. Just above that, Mr. C. Sharma, the Standing Counsel, NC Hills, shall furnish a copy of the notification dated 15/2/2005 and the office memorandum dated 31/12/1996 to the Learned Senior Counsel for the petitioner within the course of the day. So,
Highly obliged.
then after that, you say on request.
Item one, motion.
I have contacted the DC office Nagaon, my lord. They says it is the department who intimates the.
That's why this order was passed.
Yes, my lord, the direction was made to the department.
Kaushik.
Be cautious.
Or otherwise it can be remanded back if it is.
Lordship may remand back the matter, my lord, since that there was no vacancy, my lord. My lord, I have prayer, my lord. Since, my lord, this was not never considered, my lord. One time, my lord, consideration is required, my lord. Therefore, my lord,
Your case has never been placed.
No, it
was
placed,
placed
it
but
was
not
rejected in the
considered.
year 2016.
Because of want of vacancy,
vacancy.
want of vacancy, this could not be
Let
considered.
us see your case.
Yes, my lord.
The first consideration was on 14/12/2016.
Yes, my lord. And because of want of vacancy, my case could not be considered, my lord. Then, thereafter, my lord, page 31, annexure 11, my lord. This is another minutes of the DLC meeting, my lord. And my name appeared in serial number 31, page 32, my lord. The last name. Page 32, last name, my lord. In the remarks column, it is mentioned that not recommended due to want of adequate vacancy, my lord. Kindly have a look.
Adequate vacancy.
Yes, my lord, page 32. Same reason has been assailed, my lord.
So that, what you call that, clause 15, I think.
Clause 15.
Clause 15.
Huh?
Yes, my lord.
Where's that?
It's not the next year.
It could not be
No,
annexed.
if there is
Sorry for that.
no vacancy
If
in the
there is no
department, so in various departments.
In any other department, my lord,
Which department?
may be considered.
1/6/2015.
1/6/2015, my lord. Office memorandum.
Okay, under this you consider.
Yes,
But
my lord.
again, the new OM has come.
That will be seen later. My lordship will kindly dispose of at this stage, my lord.
Heard Mr. Dennis.
My lord.
I'm not London Council for the petition. Also heard Mr. MS Escutia, Leonard Studying Council, Elementary Education for the respondents.
1, 2, and 3.
1, 2, and 3, and Mr. G. Begu, Learning Government Advocate for the respondent. Stop. Para. Your mother, is it?
Mother, my lord.
The mother of the late Kanan Bala Mandal, while serving as assistant teacher, comma, 1 number
Patholiati,
Bataliati LP school
LP school.
in the district of Nagaon, died in harness on 18/7/2015. Stop. Thereafter, comma, a petitioner made an application for appointment on conditional grounds on
18/8/15.
18/8/2016 or 15?
15, my lord.
Where's that?
My lord, in the application annexure, my lord. Lordship will kindly have a look. The application I have annexed. Page, my lord, 21,
On 18/8/2015.
2015, my lord.
Stop. The district level committee in its meeting held on 14/12/2016 considered the case of the petitioner. However, his case,
He is, my lord.
his case would not be considered, was not recommended due to want of vacancy. Stop. The concerned district level committee now go. Again, in its meeting held on 15/5/2017, consider the case of the petition. However, his case could not be recommended due to adequate vacancy. Stop. Being aggrieved, comma, petitioners before this court by way of the present petition. Para. Clause 15 of the OM dated 1st June 2015, issued by the Department of Personal Personal within brackets provides that if sufficient vacancies are not available in any particular office to accommodate the persons in the waiting list for competition appointment, it is open to the administrative department, public office, to take up the matter with other departments, public offices of the government, to provide an early appointment on compassionate grounds to those in the waiting list. Para. A perusal of the meeting minutes dated 14/12/2016 and 15/5/2017 of the district level committee now clearly indicates that the committee failed to apply clause 15 of the OM dated 1/6/2015 while considering the case of the petition. Para. Accordingly, matters remanded back to the concerned to the concerned DLC.
Yes.
To recommend to reconsider the case of the petition in terms of clause 15 of the OM dated 1/6/2015 in its next immediate step with the above observations and directions repetitions.
I'm deeply obliged, deeply obliged.
Thirty-two of supplementary admission.
Affidavit has been filed here. Everything has been filed here.
When did you file it?
On 29/2020. Last Friday.
Okay, none appears for the petition. The respondent number 2, Public Director of Secretary Education. Assam.
Lordship, an excuse also. Engaged advocate is Lordship on court number 3, Lordship. So maybe time being, Lordship. Maybe time being, Lordship. He's on leg at court number 3, Lordship.
Wait for some time. If you're not ready, we'll adjourn after the additional consent.
Look.
18 of Delhi order.
Without upgrading also, they could have taken up the matter. IIT. Yeah.
Lordship, this IA has been filed with a prayer to issue a direction to the authorities of the Lordship. Actually, the post of economics in Rongia College is due to the pendency of this case, Lordship, it has not been filled up, Lordship, and I am praying for a direction so that the post may be filled up, Lordship. This has been filed with regard to that only, Lordship. Lordship,
My friend appears for the petitioner. This Lordship, he is already, she is already serving in Anandaram
No,
Dhekya.
what direction do you want in the IAS?
Lordship, actually, earlier occasion, Lordship, we both the party requested to close the petition, Lordship, to hear the petition, Lordship. And I sought time, Lordship, to produce a similar case judgment, Lordship, ordered by this.
1 minute, 1 minute. Why is it coming for orders then? You be this way.
Because I is pending, Lordship.
IAS pending.
Matter is, Lordship, simple, Lordship.
Due to the pendency of this case, Lordship, we could not fill up the post of economics in Ramia's college, Lord.
You are the principal.
Yes, Lordship.
Here, Lordship, petitioner is same, Lordship, only college is defined, Lordship. And affidavit is same, which says I have annexed this petition, Lordship. Regarding marks, Lordship, paragraph number 6, Lordship. আগৰ এডিপি কলেজৰ একে লাইনতে ঘূৰাই পাতিছিলে কলেজত দুইটা মানে সিলেকশন কমিটি ডিসাইড কৰিব আৰু
What is your case in the petition?
That's in the petition he has filed in Lordship.
I have filed, Lordship. My case was, Lordship, there is an office memorandum, Lordship, in Government of Assam, Lordship. As per the office memorandum, the marks has to be calculated, Lordship. The marks of the petitioner and respondent has to be calculated. While interview has been conducted, Lordship, they have conducted the marks, Lordship, and this as per the office memorandum issued by
You come to the point.
Lordship.
There was an advertisement.
Lordship, there is an advertisement, Lordship.
Where's the advertisement?
28, 2019.
Page.
Lordship.
Lordship, page, Lordship, 25, Lordship.
Page.
25, Lordship. Economics, Lordship, assistant professor, economics. 28, 2019.
You are concerned with assistant professor economics.
Lordship.
Not the other post.
Not other post. Then, Lordship, interview was held.
What is the date of this advertisement?
28, 2019.
28?
28th of August.
28th of August. 208, 29. 2019. Then interview was held (2011) 2019. Then interview was held, Lordship, 2011 2019. And the petitioner sought some information through RTA, Lordship. RTA was not given, but ultimately given, Lordship. And then, Lordship, they have provided the consolidated statements of marks, Lordship, page number 34 onwards, 34, 35, 36.
Page
34, Lordship.
You filed in RTA.
Yes.
It was not provided.
Not provided. But
So you came before this court.
But after this court, Lordship, they have provided page number 34. 30 numbers of candidates applied for the post of assistant professor, Lordship. 17 of candidates present, attended, Lordship, interview was failed. This is for information. And Lordship, kindly see marks, Lordship. See. CGPA category, Lordship. Page number 35, Lordship. CL number 17. Page number 35, Lordship. Selected candidate was Mohidul Hassan. Mohidul Hassan. He has been awarded 22 marks in column number 4, Lordship, in GU CGPA.
Yes.
But the as
Who
per
is
the
this Mufidul Hassan?
Mohidul Hassan is
Oh, you're the respondent.
yes, one.
Number? What's your name?
My name is Kadlisi, Lordship, page number 36. Nirmala Devi, Lordship. CL number 19, Lordship. Dr. Nirmala Devi.
Yes.
Lordship, my case was that I was not given 2.6.5 marks under the column number 03, Lordship. Column number 3, Lordship, I have given 11.50 marks, Lordship. Here is the office memorandum, Lordship. As per the office memorandum, I have to get 2.65 marks, Lordship.
I don't understand.
The calculation he has given.
You're not prepared.
Lordship.
You can't prepare. This court can't keep on waiting like this.
Paragraph 12, he has given the calculations.
Paragraph?
Yes, yes,
Where-
page number.
Page 11, paragraph 12.
Page 11.
Paragraph 10, he has stated that he ought to have got 2.99 marks more.
No, how do you calculate this?
Lordship, can it be after some time, Lordship, I will calculate it. After some time.
That will fix a different date.
Lordship, otherwise we are suffering because of this, Lordship. Because this college is running without the teacher, Lordship, and the students are suffering.
Without the principal.
Without the assistant teacher in economics, Lordship.
Assistant professor. So what do you want?
Lordship, at least the post may be allowed to be filled up, Lordship.
By whom?
By us only, Lordship, since there is no stay order. But if he succeeds, Lordship, then there might be some problem. But otherwise, she is also engaged, Lordship, in under college, Lordship, not in this college.
Lordship. When I am, according to my calculation, I should be top, Lordship. Okay? Question is simple, Lordship. According to my Lordship, my petition, my PR, Lordship, I should be top. But in spite of me, Lordship, some marks has not given to me. And
that's what this court is asking you. How much are you supposed to get? How much the
Lordship,
respondent?
I was
how much the mark of respondent number 5 has to be deducted?
Lordship,
that's all. You can't give us. You can't give this court that answer.
Lordship is para number 10, Lordship. I have given para number 10.
Yes.
The petitioner is going, Lordship, that did not appoint, she had not given 2.99 marks, Lordship, all total, Lordship. I am
On what basis are you supposed to get
Lordship,
2.99?
yes, Lordship, there is a office memorandum, Lordship.
Where is that office
Yes,
memorandum?
Lordship. Office memorandum is, Lordship, kindly see page number 39, Lordship, 38, 39, 40, Lordship.
Hmm?
30, 38 onwards, Lordship.
Election process.
Selection process, Lordship. %22 of 39, Lordship, to degree, Lordship, 39 page, 22 marks, Lordship. Can you see 22% of the total percent of marks in honors major subject for honors of the major students, Lordship. 22% should be given to the percentage as per the office memorandum. And my marks, my percentage of my marks was, Lordship, in the RTI reply, Lordship. The RTI reply says 64 point, but you kindly see page number 36. 64.30%, Lordship.
Oh, you come prepared. I can't keep on looking. On request made by Mr.
The Mahanta.
D. Mahanta, Learned Counsel for the petition. When?
Any day before Puja. It is urgent.
Yeah, it will be difficult.
Immediately on reopening.
This matter immediately after the application. You can make a mention if this.
May I please do, Lordship? Lordship, I beg to mention item number 19. It is a hearing matter. My senior is severely ill. Actually, he is having back pain.
Who's your senior?
RC Saike.
So what do you want?
Lordship, after verification.
On request made on behalf of our society and the council of petitioner. Please stop with me.
I am being for respond number 6 line.
Mr. S.K. Mukhtar, Learned Counsel, higher education. Mr. As thus, the standing counsel request for the higher education department and Mr. S.K. Mukhtar, Learned Counsel.
That's number 6.
Like.
Petitioners, both the petitioners and others who were there, they went there. Probably some of them got drunk. Petitioner number 1 in petitioner in item number 1 has admitted that he has consumed alcohol. That paper is also with me. Now, my lord, thereafter they enter into a fight. Fight escalated, where the local persons from that locality also got involved. That fight continued on 8/8 inside the IIT campus also. Then on 12/8 on Saturday, when these people again went out, because that EA was not settled on that time. When they went out, again the fight started.
on that day, more people joined in from two different groups. So IIT had identified two different groups who were involved in the fight. There are more persons, but not everyone could be identified. That we have stated also, that not everyone could be identified because the students were not cooperating at all. At all. That recording is also there. Now, thereafter, my lord, some of the students approached this honorable court on November 2023. The decision of the SDC, my lord is aware, once an indiscipline takes place, SDC sits in IIT or other committees are there. The SDC set. SDC given his recommendations. Recommendations were accepted by the competent authority, and accordingly, an order dated 29/9/2023 was passed. After passage of this order, some of the students, including the petitioners here, have appealed before the BOG.
Order was issued.
My lord, that order is 29/9/2023. So they appealed against this order of 29/9/2023, where my lord, I will take this quote. I'm just laying down so that this I can then jump up. So what has happened, my lord, thereafter? Some of them appealed, including the petitioner here also, appealed. But out of them, 5 persons, Shashank P. Marak, writ petition number 6530/2023. My lord may note down this for the convenience of this honorable court. Otherwise, I will give it in writing. Akshat Pratap Singh, writ petition number 6529/2023. Rohita Sharan, 6531/23. They approach this honorable court first. And this honorable court, with a order dated 10/11/2023, allowed them to sit in the respective end semester examinations. My lord will remember. End semester examinations of that respective semesters. Somebody were in 5th semester, somebody would have been 7th semester. Correspondingly, they were allowed. Thereafter also, my lord, Rishi Harit, writ petition number 6676/23 and Bhavesh Sharma 6680/23. They filed writ petition. These 5 persons out of the total 16 persons filed writ petition because the BOG was not in their BOG was not deciding. They approached this honorable court. After filing the appeal before the BOG and interagram BOG deciding it, they approached. And accordingly, this honorable court allowed them to sit in the examination. How this case is different, my lord, is these people approached this honorable court in item number 31. Now, my lord will take up item number 31 first. There's a small matter, probably I will be able to assist this honorable court. Then that is Kumar Gaurav. Petitions court. Kumar Gaurav, man. Petition number 879/2024.
Yes.
Yes, my lord. So, this gentleman approached this honorable court on 12/2/2024, my lord. Within prayer, the prayer portion is allowed, is there in page number 15 and 16, my lord. My lord can turn to page number 15 and 16 and see the prayer. Prayer is this. Let me paraphrase, my lord. Set aside and quash impugn order 29/9/2023, annexure 2 and 24/1/2024. That is the BOG's order, my lord. Because they are basically coming after the BOG decision has been given. So these two orders, annexure 2 and annexure 4 of the writ petition. Secondly, they sought a direction. Secondly, they sought directions from the respondents to the respondent to make up the loss of the petitioner's classes and academic reliefs. That, my lord, will find upon cause and causes at the last line of that page. Shown hearing the parties, be pleased to set aside and quash impugn orders and pleased to direct respondent to make up the loss of the petitioner's classes, page number 16, my lord. Classes and other required academic activities, and to allowed him to participate in institute's placement, sit in the 6th semester examination, and make provisions to allow petitioner to sit in the fifth end semester examination or be pass any order subject. So he said quash annexure 2 and annexure 4, that is the order of BOG and order of SDC. Then allow him to make up losses. IIT should make up losses. Third is to allow him to participate in institutional, that the placements of IIT. Allow him to sit in the sixth semester examination and fifth semester examination, which had already been over by that time. This honorable court to direct IIT to conduct this examination for him as a speech. Thereafter, my lord, what had happened? An order dated 14/3/2024 was passed. My lord will look into that order of this honorable court. That is probably now there, my lord. Last occasion, this order was probably not there. 14/3/2024.
Yeah.
My lord, let me read that order. So, he was before Justice Kite. Heard S.J. Sharma, learned counsel for the petitioner. Also heard Mr. A.B. De, learned standing counsel of IIT Guwahati for the respondent number 225, and Miss R. Devi, learned counsel for the respondent number 1. Mr. A.B. De, learned standing counsel on the instructions submitted that all disciplinary cases of the institutes, including the case of the petitioner in the present writ petition, that is 879 of 2024, Kumar Gaurav, 87, that is item number 31, my lord. 674, that is WB 674 is Yash Sharma, item number 30. Padyum Dikshit, 676, WBC number 881, Adesh Kumar Patra shall be reviewed by the Board of Governors, which is scheduled to be scheduled on 22/3/2024. Considering the above submission, this writ petition stands adjourned for another 2 weeks. It is provided that Board of Governors shall consider the case of the writ petitioner within a week from 22/3/2024 and pass orders and communicate the same to the petitioners. Further considering that the classes, my lord will mark these lines, my lord, for a moment. Further considering that the classes of the students are being hampered, in the interest of justice, it is provided that in the interim, the authorities are directed to allow petitioners, namely Kumar Gaurav, Yash Sharma, Pradyum Dikshit, Adesh Kumar Patra, to attend their classes till final decision may be taken by the authorities. List the matter on 24/4/2024. So, we intimated this honorable court that the BOG is capable of reviewing its own decision. And BOG took permission of this honorable court. With the leave of this honorable court, the order of 29/9/2023, Annexure 2 and 24/1/2024, Annexure 1 was reviewed, my lord. And thereafter, my lord, a order of 1/4/2024 was passed. I will take this honorable court for a moment, my lord. Let me just place it. So 1/4/2024 had come into existence on that time. BOG sat in their 117th BOG meeting, and accordingly they passed an order. This content of the order was intimated to the petitioners herein also. Thereafter, my lord will turn to order of 4/4/2024. 4/4/2024. Now, my lord will see that on that 4/4/2024 order of this honorable court, we brought to the notice of this honorable court the development which is taken place. Petitioner had said that they will not file any affidavit bringing this document into record for the reasons best known to them. I'm not on that. We said that we will file and we will bring into the notice of the honorable court. So, my lord, then what has happened? Then they file an IA. That is IA Civil number 1162/2024. My lord will take up that IA for a moment. To me, water tank back on
IA
1162, my lord. So, in the chronology, my lord, writ petitions come on 12/2/2024. Prayer is made. I'm sorry. So, what I'm 12/2/2024 writ petition come into existence. Then with the permission of this honorable court, on 14/3/2024, we make a submission from IIT Guwahati that we are reviewing the entire cases, all 16 cases, because the SDC had punished 16 people. All 16 cases have been reviewed. And accordingly, respective orders were being passed and petitioners herein were intimated. Thereafter, my lord, what had happened, with the leave of the court, we intimated this thing on 4/4. After 4/4, they file an IA, that is IA civil number 1162 of 2024, whereby they make three broad prayers. The prayer will find it, my lord, at page number 9
of the IA.
Of the IA, my lord. Why I am going by prayer wise, my lord? My lord will see the argument which I am trying to converse, my lord, is this, that probably in light of the present circumstances, these prayers does not require any further consideration from this honorable court. This is my larger premise which I am going to establish. This is from that is the reason I am going prayer wise. The first prayer which he has made, my lord, is this, that modify the interim order dated 14/3/2024 and order dated 4/4/2024 by directing respondent to allow registration of the petitioner for 6th semester. Then for a direction to the respondent to allow petitioner to attend all courses and programs required for 6th semester with hostel facilities. Lastly, he said, allow him to appear in 6th end semester examination. So now, my lord, if my lord allow me, then I can read the prayer if it is. It is therefore prayed that your lordship would be pleased to modify the interim order dated 14/3/2024 and dated 4/4/2024 by directing respondent to allow registration of the petitioner for 6th semester, and further be pleased to direct respondents to allow a petitioner to attend all courses and programs required for the 6th semester with hostel facilities. My lord will mark the word hostel facilities here for a moment. Further be pleased to allow the petitioner to appear in the 6th end semester examination. Then, pending disposal of the petition in the interim for the ends of justice, be pleased to direct respondents to allow registration of the petitioner for 6th semester. Further, the same prayer, my lord, has been EA. And at the last, at the page number 10, after end, be further pleased to allow petitioners to appear in the 6th semester examination scheduled to start from 27/4/2024 or on any other dates as may be postponed or proponed. It should have been preponed by the respondent, and be plus such other orders. This IA was filed. What has happened after that IA? My lord will look into the order of 25/4/2024. This, after the IA, the matter came for an adjudication again, and an order dated 25/4/2024 was passed. 25/4. My lord, let me just see. I have paraphrased it. Let me just read that paraphrase. That on 25/4/2024, the aforesaid interlocutory application along with the writ petition came before this honorable court. During the court's argument, petitioner submitted that the final examinations were scheduled to commence from 27/4/2024 or on approximate date, and he was not being allowed to take part on the said examination. Upon hearing both sides, this honorable court allowed the petitioner to take part on the 6th semester final examination, as this court had already allowed the petitioner to attend classes.
Reading which order?
That is, my lord, 25/4. I am just reading the paraphrase versions. My original order is probably
okay. Otherwise, it's not telling with this.
Yeah. Let me just, on that case, my lord, I'll read through that. Sorry, my lord. Sanjay, just find that book with the order. My apologies, man. Let me just. My lord, the larger point remains this, my lord, which I was trying to lay emphasis upon, that this honorable court allowed the petitioner to sit in the ensuing examinations on the basis that from 14/3 they have been allowed to attend classes. My lord, let me now read that. I'm sorry, I got the word. Heard Mr. S. Sharma, learned counsel for the petitioner, who, by referring to the order dated 14/3/2024, my lord has got that. passed by this honorable court in the connected writ petition bearing number 879/2024 had submitted that this court has permitted petitioner to attend classes till final decision is taken in the matter by the authorities. Mr. Sharma, learned counsel, submits that in terms of the said direction passed by this honorable court, the petitioner was allowed to attend classes. However, his attendance was not being recorded by the college authorities. Mr. Sharma, learned counsel for the petitioners, further submits that sixth semester final examination of the petitioner is scheduled to commence from 27/4/2024 or on approximate date thereto, and the petitioner is not being allowed to take the said examination. In view of the fact that is the direction, my lord. In view of the fact that the court had already allowed the petitioner to attend classes, this court is of the view that IIT Guwahati authorities shall allow the petitioner to take his sixth semester examination. In this case, sixth semester of item number 31. In the case of item number 30, it was eighth semester. However, the result of the said examination be not declared without taking leave of this honorable of this court. The IIT Guwahati authorities for the said purpose shall take all requisite steps facilitating the petitioner to appear in the said sixth semester examination. My lord. As the chronology goes, my lord, page number 73, 72. As the chronology goes, my lord, once the order of 14.3 was passed, petitioner were allowed to participate in the examinations, classes. And based on this fact that they have been allowed to attend classes, order of 25/4 was passed. A submission was made from the petitioner side that they were not allowed. They were not allowed. My lord has seen that submission that they were not allowed even though the court is allowed, but IIT authorities are not recording the EA. I have the attendance record in original now, my lord, with me. I will produce this. And my lord, I will demonstrate. Probably that statement is not correct. Petitioners, in this case, the petitioner in item number 31 has not at all attended classes. Same is true for petitioner in item number 30. Why it has happened, how it has happened, I'll produce. Now, my lord, we'll now turn to the fact that after that review, what order was passed? Let me just plug in one small detail here, my lord. Is this that even though their results, they have participated in the end semester, their results IIT had not declared, because in the opinion of IIT, they did not, they violated the court's order, granting them the privilege of sitting in the examination. That result is there. Now, my lord, will turn to page number 72 of my affidavit.
In the writ petition.
In the writ petition. So this is the initial factual chronology, my lord. What has happened till 25/4 in nutshell. Now, that is, my lord, dated, I think that is dated in item number 31. My lord has got that affidavit?
Yes.
Yes, fine. Now, my lord will turn to page number 72 now. That is the order which has been passed in review. Now, let me start by stating this, my lord. A completely fresh direction was passed. Now, before going to page number 72 for a moment, let me read what was there in the original order, so that this court can get in context from where it is coming. That original order is page number 19 of the writ petition. Let me read that order, my lord, then probably the context will come. My lord will keep both the orders side by side and see how the second order was passed. Page number 19 of the writ petition is the original order. My lord, if I may. Regarding disciplinary action, Kumar Gaurav, regarding disciplinary action, that is, I am reading the original order first. Regarding disciplinary action in connection with your involvement in the conflict between the students on the campus. Mr. Kumar Gaurav, dear Mr. Kumar Gaurav, this is in connection to the incident regarding your involvement in the conflict caused on the institute campus. As per the records received, you are among the students who were involved in the incident, which resulted a conflict situation on the campus on 8/8 and 12/8. Argument has been canvassed by the petitioner side repeatedly. Like, there is no reference of 8/8 incident. I was not there in 8/8 incident. I was only there maybe of 12/8, or the vice versa. That I was only there on 8/8. I was not there on 12/8. But the authority has looked the entire incident together. Point one. The students' disciplinary committee met on 14/8/2023 and 16/8/2023 in the Student Affairs Conference Hall to discuss the matter. You were given an opportunity to present your case in the meeting where you submitted a statement to the committee wherein you had admitted regarding your involvement in the incident. That admission part is also there. Original record of statement is there, I'll take. Malu will turn to overworlding. Then pursuant to the Malu has got that what? Pursuant to the approval of the competent authority, the understand is to convey the following action against you. You are given an academic expulsion with an immediate effect for a period of 1 year, that is till June 2024. You are expelled from the institute hostel for the entire duration of your academic program. With the immediate effect, the hostel room must be vacated within 5 days from the receipt of the letter. You are not allowed to take part in institute placement. You are not allowed to attend convocation physically after you complete your academic requirement. Let me pause here for a moment and let me place something, my lord. So, my lord has seen in the original writ petition, the prayer and the prayer in the IA. Prayer in the writ petition was fourfold, that this allowing hostel facility was not there. But subsequently, IA has been filed, that is 1162, and this gap was also plugged in, probably. Now, let me read the order dated 1/4/2024, which is available at page number 72 of my affidavit. This order came into existence because of the review which has been done by the EA from the leave of this honorable court. My lord has got that order. Let me read, my lord. This is with the reference to the incident regarding your involvement in the conflict situation caused in the campus as per letter dated such and such 29/9, the same order, my lord, which I read. The institute reviewed the penalties imposed on you, reference such and such, and considered that you have sufficient time to reflect on seriousness of your actions. The institute has favorably considered to reduce the penalties as stated below. First, you are allowed to avail hostel facilities from July 2024 under parental guidance. Hostel facility, which was taken out from by the 29/9 order, and a prayer was made in the IA, that prayer was allowed without interference of this honorable court. You are allowed to take part in the institute's placement on the condition that you do not violate any code of conduct of the institute during the rest of your academic program. Institute placement, the prayer number 3 on the writ petition was also given to them. Since IIT Guwahati follows the continuous evaluation process to assess students' performance in the given semester and grade accordingly, and considering that 3/4 of the current semester is already over, it may be noted that your academic performance will be affected due to limited evaluation, and therefore the committee recommended to permit you to attend classes freshly from July 2024 session. Further support may be extended to you to take additional courses as per rules to compensate and complete the program at an earliest. Last, you are directed to submit an undertaking signed by you and your parents stating that you will abide by the institute rules at all times. Let me pause, my lord, and let me ask this question to myself, that as an institute, how do you recover loss of a student CA? As an institute, we give them additional classes, additional programs, and support them. The another prayer which was made in the repetition, prayer number 2, direction was sought to make up the losses. That is also been granted by the institute. Now, what has happened, my lord? Let me give a context here also. IIT, my lord, will remember, IIT follows a continuous evaluation process. It is not an university where there is 2 exams or 3 exams or 4 exams. The classes run continuously. Everybody is judged on the performance in their classes, their quizzes, their assignments on a regular basis. Midterms are there and terms were there. Now, petitioner hearing in the 5th semester had only participated till 29/9/2023. It is an undisputed fact. Whatever evaluation was there, that evaluation stopped from 29/9/2023. There was no prayer before this honorable court to allow them to further evaluation. In some cases, the court has allowed wherever the people has come timely manner. This gentleman, after that particular 5th semester was over, comes before this honorable court and makes a prayer. Obviously, for good reason, that could not be accepted. What IIT rather told him that because 75% of your entire semester was over, thus they proposed you join from the July onwards so that your academic losses can be minimized. They joined from July onwards. These petitioners are doing classes, are doing whatever is necessary now. Now, let me also tell this honorable court another important fact here, my lord, is this that the issue of placement was also looked into, and the issue of academic expulsion. The order which clearly stated that they were given academic expulsion. My lord had seen that till June 2020. Now, what had happened, my lord? When the BOG reviewed the situation, they thought in their wisdom that let that academic expulsion be completed. On 31/3/2024, till that time, the academic expulsion was there because there is no mention of academic expulsion in this order. So what I submitted before this honorable court, and that is form of my affidavit it is there in my affidavit also, that the academic expulsion portion was virtually taken out by the IIT authorities from the date of passage of this order. So from 1/4/2024, the academic expulsion part, which was supposed to continue till July 2024, June 2024, that was also modified. Because this order doesn't talk about it. And in my affidavit, this position was absolutely made clear by the IIT authorities. I'll take this honorable court to that order. Now, thereafter, what has happened? Now, for that, my lord, this 1/4/2024 order, last time it was been argued, not argued, but pointed out they do not know which authority has passed this order. So I had shown this honorable court the original records last time. These records are also there. That in this order of 1/4/2024 was passed in lieu of the BOG resolution, passed in 117th BOG meeting, which had held on 22/3/2024. My lord, may kindly note that date. BOG resolution had taken place, BOG meeting had taken place, 117th BOG meeting, my lord, sorry, had held on 22/3/2024. In lieu of that, 1/4 order was passed. So what is 1/4, my lord? 1/4 is nothing but it's a communication.
When was it held?
On 22/3/2024, my lord. That record is there. My lord, if my lord wants to peruse, I don't want you to trouble this court, but my lord may look into this. I thought the original records I'll produce one go and then because this breaks my. But my lord may peruse it for the convenience, my lord. Now, my lord, what had happened? At the bottom part of it, the bottom part of it, it was there, my lord. Item 19, my lord. Thereafter, the competent authority, director was given charge. Now, under section 17 of, what is that? Yeah. Under section 17, my lord, of IIT Act, director is the ultimate disciplinary authority of the IIT Guwahati, 17.2. And my lord will see 17.2 and also 7.4. 17.2. My lord will keep these books probably because in the course I'll come back to this. So regular director of IIT Guwahati is the ultimate disciplinary authority for maintaining discipline. First, my lord will see 7.4. 7.4 is the chairman of the BOG and what powers he has. So chairman of the BOG is the director himself, is the chairman of the BOG. My lord, may I just mark that part? And
what is this called?
It is called statutes, my lord. IIT Guwahati statute. My lord is looking into the statutes, the big book. Statutes of IIT Guwahati. That is 7.4 is the chairman's power. Who is chairman? Chairman is the BOG. BOG chairman is the director himself. And 17.2 of the act. My lord will turn to 17.2. Let me read 17. That is director. 1. Director of the each institute shall be, my lord. Page number 15, my lord. 17.1. Director of the each institute shall be appointed by the council with the proper approval of the visitor. In this period, my lord, let me just plug in a small detail also here. Regular director was not there of IIT Guwahati. His appointment was, that in charge director's appointment was interfered by this honorable court. And the charge was given to a director of IIT Ropar, Punjab. That gentleman was to travel. So there is maybe some lag, administrative lags were there. 17.2, my lord. Director shall be the principal academic and executive officer of the institute and shall be responsible for the proper administration of the institute and for imparting instruction and maintenance of discipline therein. So this delegation was done by the BOG to take care of it. Now my lord has seen what is 14.1. Sorry, 1.4. How 1.4 order has been passed. Now my lord will take up my additional affidavit. Additional affidavit dated 28/2024. So I am putting everything into chronology, my lord. Trying to, my lord, that so that this honorable court gets an idea of what has happened, when it has happened, and how many benefits the petitioner has already taken. Now, my lord will turn to my additional affidavit dated 28/2024, filed in the case of Kumar Gaurav, page number 158, my lord. My lord has got it? 50, sorry, my 50. Sorry, my lord. It is page number 151. Thank you. My lord will turn to page number 152. My lord is look got into page number 152, my lord.
Yes.
Yes. So para number 4, my lord, it gives a total chronology. What has happened? Developments. 29.9. I'm not reading because I don't want to travel this code. Yeah. So what happened? Let me start from 1.4. Next page 1.4. Petitioner said reduce penalties. Then 22/6/2024, Student Affairs Office communicated with the Kumar Gaurav through email for registration plan and submission of an undertaking by 26 June 2024 and plan for the course in discussion with the faculty advisor. So faculty advisor, my lord, here is very important in IIT system because faculty advisor is someone who helps somebody to pick up courses. So immediately IIT realized that this student's career is very important. They also from their side, whatever was possible, they were extending. So the moment before that June period, July starts from, because they were asked to join from July, this mail was sent to them. On then 29 June, considering no inputs from the Kumar Gaurav, a reminder email was sent. 8 July 2024, an email was received from Kumar Gaurav along with a filled-in undertaking with modifications to the original. Because undertaking they were supposed to submit, my lord has seen point number 4. Undertaking they were supposed to submit. Duly signed by EA. On 8 July again, as this EA, Student Affairs Office communicated with the Kumar Gaurav through email, advising him to resend the signed undertaking without any modifications to the original format. 14 July. Since no input from Kumar Gaurav was received, yet another gentle reminder for submission of undertaking was sent on 14 July. Then on 19 July, an email was received from Kumar Gaurav along with a field undertaking duly signed by Mr. Kumar Gaurav and his father. Additionally, a letter was attached addressed to the Dean of Student Affairs containing Kumar Gaurav additional comments. That is there in page number 163. I will take this honorable court. Let me just read this. Thereafter, on July 21st, 2024, Dean Student Affairs communicated with the Mr. Kumar Gaurav to visit the campus for registration purpose. 24 July, Chairperson of Hostel Affairs Board communicated to the Kumar Gaurav regarding his hostel accommodations. The hostel accommodation was given. The list. Then on 25th July 2024, a list of courses was proposed by Mr. Kumar Gaurav in discussion with the faculty advisor and approved by the academic section, and he started attending classes. On 26th July, father of Kumar Gaurav and Mr. Kumar Gaurav met with the student affairs official on 24th July and 26th July 2024 to further discuss the registration formalities. Subsequently, in view of the letter dated 1/4/2024, a written request duly signed by Mr. Kumar Gaurav was submitted by him requesting for a hostel stay without parental guidance and to take additional courses for placement. Now, let me just take this honorable court to this particular letters so that this honorable court can appreciate what is, how it is fallen everything into picture. I'm sorry. Okay. My lord, we'll turn to page number now 164. 164, my lord. Those previous emails are there. I'm not troubling this honorable court. From 58, these emails were there. If this honorable court wants to peruse, my lord may, but I'm not troubling. I just want to show the important part so that, my lord, I can finish the argument, my lord. So 164, my lord, is his undertaking. Now, let me just with this course, my lord, let me point out something. He was allowed hostel stay without parental guidance, and he was allowed to take additional courses as per the rules. That was the decision of the director. As per IIT rules, my lord, BDS regulations. As per IIT rules, my lord, a student in 6.1 in BDS regulation, you give your regulation extra copy. My lord, we had given this BDS regulation, but if this honorable, I can give my copy now. If give an extra copy to the court. My lord, will peruse 9.3. Page number, my lord. My lord, will keep this regulation because I will come back and forth to this. 9.3. 9.3, my lord. This was the original EA. 9.3, my lord, will see. During the registration following, my lord, this is BDASH regulation. My lord will see the at the beginning of this. It is basically ordinance, BTEC and BDASH ordinance and regulations applicable to from 2010's batch, revised up to 127 minute of Senate and 88 Senate. So IIT Guwahati, my lord, apart has ordinances. This is one of the ordinances which deals with the academic side of the student's life, if I may very crudely put it. So 9.3, my lord, at this point, my lord will peruse 9.3. So what 9.3 says, my lord, is this, if I may, my lord, the word is registration. My lord has got it. During registration, following condition must be fulfilled. A, student must pass all first year courses before registration for the third year courses. B, normally the number of credit registered during the semester should not be less than 30 and should not exceed 48 excluding minor, LTP loading for the semester should not exceed 32 contact hour per week. Now, as per our rules, it is only 48. You cannot go beyond 48. Because in an IIT, that there is so much of pressure, my lord. Sometimes the IIT regulates how much you can take. Not because this, apart from this, there are other activities are there. So IIT regulates this part. So they were allowed maximum up to 48. Now, my lord will see how the authorities has further given them exemptions. That is the reason I have read this and troubled this honorable court. Now, my lord will come back to page number 164. 164, they have given the undertaking. My lord, turn over leaf. 166 is their letter dated 19/7/2024. My lord, in page number 166. Let me read with due respect in continuation to the undertaking dated 19/7/2024. I am not reading the undertaking because this is, they have said that you will not make any violations and all that. That is what is in the undertaking. It is further submitted that I was not involved in the conflict that took place on 8/8/2023 and 12/8/2023. I have always followed the rules and regulation of IIT Guwahati and will follow the same. I should not be held responsible for any baseless and false allegations in future. In future, in case of any allegation, a fair opportunity should be given to me to defend myself. Since the punishment imposed upon me is unjustified, so I have filed an writ petition number such and such against the unjustified SDC order, which is pending before the honorable court, and matter is sub judice. Why I have read that, my lord? Because there is an additional comment I have read. There is an additional with the undertaking he has given this. Thereafter, my lord, page number 167. My lord will see page number 167. That emails are there where he has been allowed to. Thanks for submitting undertaking. You are allowed to visit campus a day before registration scheduled on such and such date and report academic section. My lord will turn over leaf and go to page number 169 thereafter. So with the undertaking, when he visited the college, he submitted this registration form. My lord, at the bottom, my lord will see the total credit points. That is 50. My lord has seen it is 48 only. And he has made a prayer. That prayer is also that he should be allowed to attend without parental guidance. That I'll also read through this. That my lord will find in page number 171. So first he makes a registration request exceeding 48 and my lord will go to page number 171. That is dated 26/7/2024 to the director regarding letter dated 1/4/2024 dated such and such 26/7/2024. With due respect, it is to submit that academic break of 1 year along with some other penalties was imposed upon me. Penalties were reduced and communicated to me with the order dated 1/4/2024, wherein hostel facilities from July 2024 has been allowed under parental guidance and was also allowed to sit in the institute placement. It is also mentioned in the said letter that support may be extended to take additional courses to compensate and complete the program at the earliest. It was also directed to submit an undertaking to abide by institute rules regarding hostel facilities under parental guidance. I have to say that my father and mother are working in Patna for our livelihood, so they cannot stay with me in the hostel. I have already submitted an undertaking to abide by institute rules in view of the letter dated 1/4/2024 for the sake of my career. It is requested to allow me hostel facilities without parental guidance. It is also requested to make necessary arrangements to take additional courses to compensate and complete the program and also sit in the institute placement. Let me pause here for a moment and let me ask myself, my lord, is it a dilution? The stand which is taken in the previous letter, probably some good he has accepted by diluting his stand the 1/4 order. once he files this. So it is not that in his previous letter, which might not have seen that he is here and all that, nothing he says that for the sake of my career, in view of the letter of such and such, for the sake of my career, it is requested to allow me hostel facilities without parental guidance, also make necessary arrangements to take additional courses to compensate and complete the program, and also sit in the institute placement. So once you try to draw benefit out of 1/4/2024 order, how can you turn around and challenge that order? Because 1/4/2024 order and 29/9/2023 order are from the, if the argument of the petitioner side is to be believed, are from the same disciplinary proceeding. My case is different, but that is the argument being conversed. At 1/4 is also from the same disciplinary proceeding, so it is the same virus is there in 1/4. I am suggesting
But that is not under challenge.
Absolutely, my lord. Absolutely. He goes ahead and he says, I am now accepting everything. Let me close everything. Thereafter, what has happened? Page number 170. Petitioner was a student of Disang Hostel, my lord. And this Disang Hostel, Brahmaputra Hostel, and other hostel, they fought. There was a specific message sent to the Disang Hostel boys group by somebody called Dipangshu Pafare. That is also there with me. He said in the WhatsApp, come with lathi and sticks and whatnot. You will teach them a lesson. That is there. 172, my lord. Dear students, please recall your letter of permission to stay in the hostel without parental guidance to take additional courses and for placement. This is to inform you that the competent authority approved your request for hostel accommodation without parental guidance, but with the condition of mandatory attendance. I have his attendance from after this. What is his attendance? What is his performance? Malad will see. I have this. Campus placement and taking additional courses. All three are approved. Following reference to the such and such order, and has permitted to complete the registration formalities and attend classes immediately. Chairperson of HAB is requested to allot him hostel room. Your attendance to the classes is compulsory, and hence you need to attend classes regularly and submit attendance. A sample format and 6 and 8 credit courses is attached every fortnight to the SS section without any failure. The same will be shared to your parents. Note that it is students' responsibility to follow up attendance. You are advised to meet Dean Academic Affairs by making an immediate appointment to finalize your courses for July-November semester and pay fee payment. Thereafter, his hostel was changed to Manas hostel, from Disang to Manas. It was there in Disang, but IIT authorities thought that communication is also there. If my lord wants to produce, I will take this honorable court to that communication also. Page number 168. In the dear Gaurav, with reference to the trading mail, you will be staying in Manas hostel for the rest of your academic program. Kindly get in touch with the hostel officers for further needful. So what I am submitting, my lord, whatever career wise, the prayer was there, the loss was the IIT wanted, how far the IIT could go, they have gone. After 1/4 order also, further benefits were extended to him in form of allowing registration in multiple more courses, and parental EA was also taken out, and his hostel was also changed so that he doesn't mingle with these people and then again a fight happens. Now my lord will turn to my affidavit again and turn to page number 55. Academic records. Academic record is original part. My lord, for a moment, my lord. My lord, for a moment. My lord will peruse para number 5. My lord, I'm just assisting this honorable. Go to the academic. The one did I'm Yes. Yeah. I'm sorry, my lord. Deponent back to state that Kumar Gaurav was provided. Huh? No, enter. My lord, I'm sorry. Deponent back to state that Kumar Gaurav was provided support from the student affairs.
Here reading.
My lord, para number 5.
Para 5.
Yes, my lord. Page 155. It agar pora dibo reda. Agar pora dibo. First page dibo.
Page
155.
155.
I'm just reading 2 paragraphs of my EA, and so that whatever I have stated that is reflected, and I'm not slipping down from that EA. Number, let's see. I am placing the original record now, but I'll take this on double code. I'll assist this code. 5 and 6, let me just state it quickly. That the deponent back to state that the Mr. Kumar Gaurav was provided support from the from the student affairs office to carry out his registration process for July-November 2024. Kumar Gaurav has submitted an undertaking duly signed by him and his father. His father and met officials of the student affairs section on July 2024. After detailed discussion in view of the order passed such and such, he submitted a request letter for a hostel stay without parental guidance to take additional courses and for placement. Despite having marginal academic performance, that performance is revised, my lord. That record is there now. I will come to that. Mr. Kumar Gaurav was permitted by the competent authorities to take additional courses to obtain hostel accommodation without parental guidance, but with the condition of mandatory attendance, campus placement. It was also permitted to complete the registration formalities and to attend classes immediately. Kumar Gaurav submitted a list of 9 courses with total 50 credit, all voluntary done, my lord, by him only, mainly focusing on 5th semester and other courses and other extra courses. Proposed list of courses was approved by the academic section. Mr. Kumar Gaurav has completed all registration formalities for the July-November 2024 semester and is currently focusing on his academics. Para 6. It's pertinent to mention that petitioner did not attend classes for the half of 5th semester and did not attend classes in the 6th semester. Hence, he was deemed not to have completed rigorous learning processes by the mandatory attending classes, participating in the discussion and continuous assessment while learning, followed by IIT Guwahati. Therefore, as per the ordinance, petitioner is not eligible to receive grades for the 5th semester and 6th semester. In view of the prayer made by the petitioner cannot be accepted by this honorable court. Further, he is also not participated in the instructions, evaluations which are conducted during the above semesters. Thus, as per BDS regulations, he cannot be. Now, my lord, we'll take a look in the original records which I've submitted. My lord, we'll take up the first file and we'll see the Kumar Gaurav's performance.
This one?
Yes, my lord. Kumar Gaurav performance, my lord. That is, original records are there, my lord. Now, with reference for Kumar Gaurav, 1. So, for attendance records for each subjects and methodology for recording attendance in July 2020, July and May 2000 semester, after direction of the Honorable Court on such and such. He was, my lord, let me pause here for a moment and let me just see it. He was not allowed to participate classes from 29/9/2023. He was allowed by this Honorable Court to participate classes from 14/3/2024. So how many classes he has attended after that? The records are there. They have said, first is data structure, algorithm, course number, my lord, in the table.
Yes.
Data structure, first, my lord. Data structure, algorithm, not attended any class. EE 393, blockchain, science and technology, not attended any class. EE 360, power electronics, not attended any class. CH 419, consumer chemistry, not attended any class. EE 370, electrical power system, not attended any class. My lord, will turn to overlay. Mr. Kumar Gaurav, after the Honorable Court's order dated 14/3/2024, allowing him to attend classes, did not contact the institute to attend classes, but arrived the campus only on 27th July 2024. My lord. On 26th April 2024, he requested permission to appear in the end semester examination annexure 1 is there, my lord. That annexure 1 is there. Everything, my lord, will see. And he was allowed to attend. And and my lord, I'm sorry. He requested permission to appear in the end semester examination by submitting a list of courses through email, annexure 1, and he was allowed to attend end semester examination. Before that, he never approached for permissions to attend classes. Continuous evaluation process, evaluation of in the academic year 2023-24. Now, 23-24, my lord, is the semester, 5th semester, and how much he is participating. So, July-November semester, the prayer was this, that you allow me pass in 5th semester, whatnot. So, my lord will see no participation, right hand column, assessment participation, no participation after mid-semester exam following the letter issued by the disciplinary authority. Now, juxtapose the situation, my lord, with other writ petitioners. Other writ petitioner had approached this honorable court. The numbers which I have given this, they have approached this honorable court. This Rishi Harit, Shashank, all these people. And this honorable court, by the order dated 10/11/2023 and 18/11/2023, allowed them to participate in the end semester. He did not come at all. Only after completion of 5th semester completely on sometime in 12 February, he came knocking before this honorable court. Now, if you approach this honorable court at a delayed stage, I ask myself, my lord, how this honorable court can help you? Now, let me proceed and show his participations in 6th semester. Now, another prayer is this: pass me 5th semester, declare result in 6th semester also. So, that is, previous semester was July-November 2023. Next is January-May 2024. That is 6th semester. Here, he has only participated in the end semester. But before that, my lord will see the distribution of weightages. My lord, in another case, my lord will remember in Deepika matter probably, my lord, we have shown how the weightage differentiates. That is, that weightage differentiation is there in clause 15.1 of the bidders CA also. So each subject will have different weightages for the assignments, for the courses, for other things. So if you only attend one component, grades for that EA cannot be declared. And if you have violated the court order, video which the court had given you that leniency, IIT cannot be asked to declare result for that. So neither grades for 6th semester can be declared, or the marks for the end semester which is they have participated can be declared. Because the participation of the end semester was in compliance, that they comply with 14.3 direction. 14.3 direction that you attend classes, you don't attend classes. He only came to this institute. That annexure 1 was there. My lord, I do not want to trouble this court, but let me just read it through. This is his letter. Annexure 1, my lord will see that is given there. With this report, annexure 1 is there. Let me read slowly, my lord. Page. My lord, it is not paginated, my lord, I'm sorry. It is not paginated, I guess. Annexure 1, but it is bundled together, I think it is. Let me read slowly. From Kumar Gaurav, my lord has gotten after this writing things gets over in page number 7. Kumar Gaurav. From Kumar Gaurav. My lord has got it.
Annexure 1.
Annexure 1. Email from Kumar Gaurav.
Annexure 3 is the attendance.
My lord, I'm sorry, probably my lord will look into this, probably then this may assist this honorable court. I think it is there, but just that these are yeah. Altogether annexures are there, my lord.
You flag it?
Yes, my lord, I'll flag it. Sanjay, flag it for it. Let me read my lord slowly, and then my colleague will flag mark this. Respected sir, I respectfully request, that is a letter from Kumar Gaurav. Kumar Gaurav sends a mail on 26th April 2024 at 10:39 p.m. addressed to Dean of Academic Affairs, Dean of Academic Affairs, HOD of Electrical and Engineering, to attachment. Huh? I'll mark it up. Just read and then I'll give it my copy. My lord will accept it. I respectfully request permissions to appear before. I respected sir. I respectfully request permission to appear in the upcoming 6th semester examination, 6th semester and semester examination beginning from 29th April 2024. The Honorable Court of Guwahati has granted me an opportunity by passing the order dated 25/4/2024, order attached. Since I will be reaching Guwahati on 27th April, so I seek to fulfill any necessary requirement, including registration, within the limited time frame. Your support in this regard will be greatly appreciated. Subject for which I seek approvals are electrical power systems, power EE 370, so that is given. My lord will see this. My lord, we find it out. We'll now mark it out. I'm sorry, my lord. This record is just came in, so did not have time to get it out. I'll give it, then we'll take it. Sorry. Now let me just, my lord, proceed. So, my lord, what has happened here is this, my lord. Sorry?
Which one is yours?
No, this is original report.
From your additional document?
No. This is original report I am reading now.
It is not here in the court.
No, it is obvious. It is there in the report. I am producing before the original report. Original report I am producing before the court. What is not there?
These things are not in the affidavit.
This is the original record I am producing before the court.
They are producing, but at least
you can see the original records are there. It is, you can inspect it.
At least
I am producing this.
Let them give me to the court.
Let him produce. Let him examine also. No, my lord. What
They
is
have
there?
submitted the additional affidavit also, with submitting the original or submitting some of the documents.
Because all this,
but still they have withheld some documents.
This is not a withholding, my lord.
Still they are
Let it be
withholding-
cleared. Let me clear
No,
this.
what you can do, you can let him see the report.
Yes, let him. He can see, my lord. I am there. It is there. He can see. This is Xerox copy of this. The original copy is there. Because all documents are not Xerox also. Some documents are confidential. But the statements of the students are there. It's confidential. I cannot give it to him. The problem is this, my lord. If the student statements are given, my lord, the guards will remain. Oh, you have stated against me. I will take it out. So all documents we cannot give. I cannot give all documents. I cannot be expected also, my lord.
Nothing is
there, my lord.
Students' statement is not confused. On the basis of some statements you are punishing me, you have to produce that statement to me. It cannot be said confidential.
Unfortunately, my lord, this is not a situation in the residential camp. For maintaining residential campus's integrity, to protect some time.
Okay.
My lord will see annexure 1.
I'm seeing the annexure.
Annexure
Because I was wondering where from this submitting. I was wondering it.
You've seen it? Yes. Not let me, if you may, let him go through, my lord. I'll continue submitting. My lord, just read that.
Yes.
Yes. So the point which I was trying to make, my lord, is this. If he comes to the institute only on 27th, as been stated, 27th of April 2024, for the first time, and he says that he writes a mail and he says that, sir, you can inspect this copy also, no problem. You can, but let me just finish it. Or I'll give you
additional copy.
No, additional copy is not that. Is just a copy which I've got. This is the Xerox copy which I have. You may look into this. I'll give you. If he comes to the institute only on 26th, he writes a mail, 27th he lands up. He did not attend any classes. He says that. Thus, the order benefit which was given to him by 14/3/2024 and consequently by 25/4/2024, he cannot claim those benefits. Now, my lord will see, my lord will come to that first page of the original record again. Now, in the 5th semester, my lord has seen, my lord will turn to the page 3 now of the original record. Page 3. Now, page 3, my lord, they have tabulated that what are the components which he is supposed to participate. What is the breakdown? My lord will say practical is, one practical is there. I'm just taking one, probably my lord will. So, data structure and algorithm, my lord, practical is 1. 15% is the weightage. Mid semester weightage is 30%. Practical 2, 15%. End semester is 40%. Now, if he only has given 40% weightage exam, the grades for that subject cannot be declared. That is my submission. With regard to semester number 6, there was only one component you have participated. That component is the end semester. That too, that was given as a conditional order. Not fulfill the condition and marks cannot be declared. Second, prayer declare grades. Grades cannot be declared because you have only participated in the one component. It is without prejudice to each other, my lord. My lord is approved. Have I assisted this honorable court, my lord? Appreciate the point. Let me again, my lord, right, my lord. So, with regard to his 5th semester, my lord, he did not participate any components after 29/9/2023. Previous page, my lord has seen. So, results of 5th semester cannot be declared. Nothing can be done with regard to 5th semester. Further, he has now taken admission in the 5th semester itself. He is pursuing it. No interference is required. Now, if you look to the 6th semester, this honorable court had allowed him certain benefits with a condition. Condition not followed, benefits cannot be taken. Thus, marks of the end semester cannot be given to him. The prayer was there to declare marks. I'm absolutely sorry, my lord. Cannot be done. With regard to the grades, because grades and marks are separate, my lord. Grades and marks are separate. Grades cannot be also declared. Because he is only participated in one, other components are missing. So, neither this honorable court will grant him any relief with regard to the 5th semester or with regard to the 6th semester, my lord. Let me now proceed and my lord will show, let me show what is his performance now. That is there in page number 4, my lord, of the original records. Attendance, my lord, I remember that in that communication to his parents, IIT said that you attend every day. Now, no living business. You attend now, every time. Now, continuous evaluation process for the 24-25. My lord, in page number 4. If this honorable court wants to exercise his power also, my lord will see, is the case fit? Now, continuous evaluation in the academic year 22, 24 and 25 and participation by the petitioner. The current, which is now going on. CH 426 Green Chemistry Technology attended 62.5 classes. Percentage attendance is only 62.5 of classes. Classes attended between 25/7/2024 to 14/9. Last updation. Participated in only one quiz. Then COS 05. Regular in classes, not applicable. Quiz was not there, not applicable. Principle of Electrical Engineering attended 17 classes out of 24, including tutorial classes. One quiz he is participated. Then embedded system, regular in classes. No assessment has been conducted so far. Principles of communication, regular in classes, attended all quizzes. Electromagnetic, regular in classes, quiz 1. Control and robotics, attended 6 classes of 6. No assessment has been conducted so far. Electrical machine, regular in classes, no assessment has been conducted so far. War and peace, military in classes, no assessment has been conducted so far. So, if the student is coming back to the curve of education by the efforts of IIT Guwahati, still on that case, my lord, this interference is not required. Whatever methodology, the idea was to assist the student, make him regular, make him participate so that his other activities he should not be doing. Now, my lord, see the last paragraph. I told there was 13%, his performance was poor. It is pertinent to note that while joining back the institute as per the BOG order, such and such, my lord appealed in 26 July 2024 to permit him for hostel stay without parental guidance. Annexure 2. Despite having marginal academic performance with 3.56 and 4.20 on the scale of 10 scale in the last 2 semesters, in 3rd semester and 4th semester, respectively, Kumar Gaurav was permitted by the competent authority to take additional courses to obtain hostel accommodation without parental guidance to avail campus facilities. So Mr. Kumar Gaurav was permitted 9 courses with a total credit of load of 50, mainly focusing on 5th semester and other courses. Mr. Kumar Gaurav has completed all registration formalities for July and November 2024 semester and is currently focusing on his academics. It is again such as the benefits have been taken and continuously they should not be taken. So, my lord, this gentleman was that way poor in academics. Now, if he is promoted also, my lord, it will create an academic burden for him. If my lord, in a very he wants to give a benefit, let me pass him in 6th semester. What will happen? His academic performance is very poor. So what I am submitting before this honorable court is this: the corrected path which the IIT Guwahati has adopted for him, let him remain in this path, my lord. Maybe because of this, his career, his EA will be salvaged. His percentage is otherwise very poor. IIT students are of 7 graders, my lord, 7 pointers. This is very poor performances. Now let me again come back to my lord, I have shown the original record with regard to his performance. Now let me come back to my EA again. Now, my lord, as he was, the point remains, I will not exert much, my lord. Let me just precisely say this. In equity also, my lord, if you have already drawn a benefit from 1/4 and if you continue to draw 1/4 benefit, you cannot challenge the order itself. And the order follows on the same disciplinary procedure. One more fear was allied on this honorable court before on this honorable court's that look, my entire career will be now stigmatized. Maybe that argument was made. Maybe that 29/9/2024 or 23 order is not there. But whatever has been recorded against me will damage me for entire of my life. That argument was made. That even though the order is not there, but the stigma is attached. With all due respect, my lord, that stigma is also not attached. Let me now show paragraph clause 5D of the ordinance, my lord. Before that, that ordinance is there in the rejoinder of the rejoinder which has been filed by the petitioner side.
Ordinance here.
Yes. Now, this is the, my lord, there are 2 ordinances.
Okay.
This is the Videsh ordinance for the academic side. For the disciplinary side, the code of conduct is there. Rejoinder ordinance. Sorry, in the appeal. Sorry, in the writ petition, my lord, I think they have attached the ordinance. Just see the writ petition. Yes. My lord will turn to page number 32. So on my larger point, my lord, which I am making, that the prayer is infructuous. Under that column, I am making these submissions. I have other two submissions also that will come to this. This is my preliminary argument. So my lord will straight away see 5D specifically. Disciplinary record, my lord has got it, page number 32.
Yes.
My lord. Sorry. At 5D, my lord. Thank you. Disciplinary records are confidential in accordance with the laws of the nation. And nothing more to submit, my lord. This can end. The contents of the disciplinary records may not be released to anyone not associated with the campus discipline except upon written approval from the student or a court ordered subpoena. So, my lord, no point of his life, anyone can access these records. No one can access this record. It is sealed. With all due respect, my lord. So, the argument that the stigma is there still. Maybe the order is not there, but the stigma is there. With all due respect, my lord, that stigma may not be also there. This record cannot be accessed without him if he permits.
What ordinance is this?
This is, my lord, code of conduct. Now, student code of conduct, my lord, it starts at the page, my lord, page 24, it starts, my lord. Page 24, it starts. So, it is basically, in IIT life, my lord, of a life of a student, there are two broad ordinances. One is for the academic side, that is that BTech, BDash regulations. And another is for the maintenance of discipline, they have this ordinance of code of conduct. Yes. Now let me summarize, my lord. My first point. Order 29, not existence. Order of BOG of, which is where they have decided the appeal, not existence. What are the order which is in existence today is 1/4/2024. From that order, IIT has also further given you more benefits. More benefits has been given to you by parental guidance and additional courses. So under such circumstances, this honorable court may not interfere because the first prayer of the writ petition that strike down the order of 29(9) and the BOG order, annexure 2 and 4 is not there. The second prayer of the writ petition, give me proper classes and all that. Now they have been given to you to take benefit of it. More courses they have been allowed to participate. They have been taken out placement. Prayer was made, placement, allow me to placement opportunity given. They said ki you take the hostel benefit given. Without parental guidance also given to you. Then there was a prayer, my stigma will be there and all that. That is also not there. So once you, in equity also, my lord, you cannot demand before this honorable court without concentrating his prayer. I pointed out this time to this, my lord, when I started my argument on the last occasion, that the petitioner has not made any categorical prayer now. In the writ petition, if the prayers are there, these prayers doesn't require any adjudication. This is. Now let me start with the second point, that can he be promoted to 7th semester and 6th semester? My lord will now first will see the BDash regulation. His performance, my lord, has already seen how many evaluations he has participated. Now that BDash regulation, my lord, that academic side, my lord will see what is the BDash regulation. Now BDash regulation, my lord. Yes. My lord will see, I am reading from this BTech and BDash ordinance and regulations. My lord has got it?
Yeah.
My lord will turn to page number, point number 15.1 in there. Let me just read respective paragraphs. I will point it out. My lord will see from the respective paragraph of my affidavit. My lord can see that. Yes. My lord has got it. 15.1.
Yes.
My lord, let me read. There will be continuous assessment of students' performance throughout the semester, and grades will be awarded by the teachers concerned or appropriate committee appointed for this purpose on the following basis. 15. A. In a case of a theoretical subject, the evaluation will be based on the instructor's assessment, quizzes, mid-semester examination, and end-semester examination. And in sessional subjects, that is laboratory, design or drawing, studio works, workshop, etc., the evaluation will be based on the attendance, assessment of tasks assigned, and the end semester test file. So, my lord, this reflects back to how many assessments he has participated. If he has not participated any assessment after 29/9/2023 for the 5th semester, he cannot be promoted by 15.1. My lord will now see 17.1 for a moment. 17.1 talks about examinations, my lord.
Yes.
Hello. In assessing the student's assignment in subjects theory, laboratory, studio, and sessional, seminar, project work, etc., a system of continuous assessment is adopted by the institute. In conformity with the practice, there will be one mid-semester examination and semester examination and semester examination for every theoretical subjects, in addition to instructors' assessment and quizzes. Full stop, etc. 17.2. A student may be debarred from appearing the end semester examination due to following reasons: if any disciplinary action is taken against him; B, on the recommendation of a teacher, if his or her attendance in the lecture, practical classes has not been satisfactory during semester or other; his performance in the sessional work done during the semester has been unsatisfactory. I am concerned with 17.2a. So IIT had rightfully stopped him from participating in the examination after 29/9/2023 order. Power was there. Only by the order of this honorable court of 25/4/2023, 24, he was again allowed to participate in the end semester examination. That too with a condition. Now, my lord, let me proceed. In view of the above, it is submitted that the IIT Guwahati follows on the Acha, my lord will also, if my lord is looking, my lord can also look into clause 2.5. Let me also at the same time take this honorable court to 2.5. 2.5. Institute reserves the right to my lord has got it. 2.5. Yes. Institute reserves the right to cancel admission of any students and asks him or her to discontinue his studies at any stage of his career on the ground of unsatisfactory academic performance or disciplinary grounds. The criteria for former will be governed by the rules and regulations, while the criteria for the latter will be governed by the rules and regulations and the code of conduct. That is the disciplinary grounds. Based upon the code of conduct, he can be detained. Now, 9.2c. 9.2c is registration. My lord, he may be debarred. I have read this through, but let me just 9.2c, that if registration can be he can be debarred also. Petitioner has been debarred from attending any academic activity from by that 29 order, my lord. 29 order, he was debarred till June from academic activities. Also, apart from the hostel and other things. 15.1, 17.1, 17.2 I have already read. My lord will see now 20.1 and 20.2. Eligibility for the award of BTech and BDS degree. So whether the provisional degrees with regard to the the petitioner can also be given. Student shall be declared eligible for award of BTech and BDS degree if he is completed all credit requirements for the degree with DD grades or higher grade in each subject: theoretical, laboratory, studio, workshop, sessional, etc., seminar and project, etc. Satisfactorily completed. B, completed all non-credit requirements for the degree namely extra academic activities, industrial training, etc. if any. No dues to the institute department hostel. No disciplinary action is pending against him. Last point. D. In case there is a disciplinary action pending against him, cannot be given any degree, any marks. Point 2, 20.2. Award of such and such must be recognized by the Senate and approved by the Board of Governors. So this is very specific, my lord. Let me come to why this is important. Until and unless you do not challenge 20.2 in your petition and say that this honorable court can exercise the power of Senate and BOG with all humbleness, my lord, this honorable court may not. The repugnancy of the rules must be challenged. Otherwise, you cannot get this, cannot make this prayer also that you let the court give me a degree. Cannot. That power is specifically with the institute authorities, Senate and BOG. Thus, my lord, what I am submitting is this regulations may be looked into, my lord. Now, fifth semester participants, I have already from the original records, my lord, have seen. My lord have also seen what is his performance and how many courses he has participated thereafter. Now, thus, my lord, I am praying, I am submitting. This is not a fit case where this honorable court may invoke power and either declare any relief with regard to fifth semester or sixth semester. My first argument was this, that EA was not there. That order of impugn order 29.9 and the BOG order not there. My second argument is this, because of this regulations and because of his not participating, any benefit with regard to semester 5 and semester 6 cannot be given to him. Let him remain in the semester which is there. He is showing maybe some progress in the eyes of petitioner. I am not commenting upon that. But if he can be brought back to the education system, my lord, it will be beneficial for him. His academic performance in the previous 2 semesters are very poor. Still, IIT went ahead and given him support, all necessary support. Now, my lord, I am on merit. I have completed my argument, my preliminary submissions. I am on merit. Now, let me submit, my lord. My lord will now take this code of conduct for a moment, because that is, I think, in the page number, my lord, in the repetition, my lord.
Yes.
Yes, my lord. Now, before reading this, my lord, before starting with the page number 24, my lord, before starting my response with the disciplinary proceeding, that argument was made by canvassed by the learned petitioner's advocate. Is this that there was clause in the disciplinary proceeding? Thus, this honorable court must interfere. One flaw which he tried to show that there was no probably show cause notice not been issued and something. I will show now, my lord, what is the disciplinary proceeding first of this, which has been IIT follows. Then we'll address the point. My lord will turn to the page number 24. My lord. Now, before that, my lord, this IIT Guwahati has adopted the ordinance that is on top of it, my lord. It has been written, approved by the BOG on 16th EA and has been modified timely manner. The code of conduct outlines the students' conduct. My lord, let me now read the introduction part first. My lord has got that introduction part?
Yes.
1, 2, third line, my lord. In the between, the code of conduct. My lord has got. Now I am first explaining, my lord, what is how this disciplinary mechanism acts in IIT. This is an institute governed by run by the student, by the teachers, my lord, and they try to address grievances of everyone, not only the one student, the local publics who are there adjacent to IIT. IIT also tries to see a situation that nothing happens which disturbs the local peace in the congenial educational environment of the institute. This incident had done both of the things, disturbed the congenial education environment of the institute and disturbed the very fragile peace which IIT has with the local people there. Some of the students went out, got drunk, abused father of a shopkeeper. Then they beaten up. Those records are there. I'll take this court through now. Because this is come up from the statements of student statements, my lord. I could not have given them immediately. There are certain secrecies there, my lord. Let me read this first, code of conduct, and explain. The code of conduct in the between third line, my lord, 1 to third line.
Yes.
In between, the code of conduct of the student outlines the student's code of conduct and disciplinary policies that pertains to the students and student organizations at IIT Guwahati. And got it? Now, 1, 2, 1, 2, 3, 4, 5, 6. The purpose, my lord has got. The purpose of the policies outlined in the code of conduct and the student is to protect rights of all members of IIT community and to maintain an atmosphere in the community appropriate for an institution of higher education. That is the purpose, my lord. Not to only help those erring students. Second is very important, my lord. The next paragraph. Interpretations of the provisions of the code of conduct may be requested by the contacting dean and EA. Thus, the interpretations of the code of conduct is only the interpretation which the dean of student affairs has taken. Students in the writ petition cannot assign a different meaning. If you want to do that, you should have challenged this. Until unless you do not challenge the repugnancy, you cannot say this clause means this. Sorry, it doesn't happen. The repugnancy has to be challenged. This is the fundamental principle of writ jurisdiction, my lord. If the repugnancy of the rule is not challenged, the rule is applicable upon the petitioner, and this honorable court has to decide the writ petition within that framework, not otherwise. Let me proceed. Scope. IITG, my lord has got the point number 2. IITG faculty, staff, and students value the institute's relationship with the surrounding community and realize that it has tremendous social, cultural, and economic impact on the community. To go there, get drunk, start beating up people, abusing people, that is not good, my lord. Policy setting and enforcement of disciplines are ways of education, are ways of educating students to become conscientious members of that community. And the students are expected to conduct themselves in a responsible manner at all times, whether off and on campus. So the punishment which has been leveled are given are not to destroy somebody's career, my lord, are given with an intention always to assist them so that they become better. Next, student discipline system exists to handle infractions against the institute rules and regulation. This system is based on the philosophy of fairness for all parties affected by the situation involving the students' non-completion with IITG policy or regulation. Student discipline system, most important, my lord. My lord will mark this part. The student discipline system is designed for an educational system and does not function as a court of law. Therefore, the procedural issues, including introduction of and consideration of evidences, are handled in a manner consistent with the educational focus, where the allegations are more serious and therefore the consequences more serious. The rules are structured appropriately. The student discipline system is not a substitute for the criminal or civil code, but an additional option for the complaints when the alleged violator is an enrolled IITG student. Thereafter, my lord, the last paragraph, 1 to 3rd line from the top. Last paragraph, after 1 to 3rd line, further the word. What further, my lord? My lord has got it?
Yes.
Further, if a student or a group of students is reported to the institute authorities for violation of off-campus, the institute may intervene on a formal or an informal basis. The informal intervention will involve in the individual student or group of students being referred to the Dean of Student Affairs or a competent authority for discussion on the incident. Off-campus behaviors which can have significant impact on the mission of the institute may invite formal disciplinary actions. So both off-campus and in-campus actions can be taken, my lord. And most important thing is this, my lord. First, the authority calls students, discuss them, understand what has happened. In this case now, my lord, when the records, original records, my lord will proceed. See, my lord will see that SDC has said before also and discussed that matter with him. In that discussion, they have stated certain things. Subsequently, they have stated certain things. With regard to the respondent number, with regard to the petition, in the item number 30, he changes his version in the last. That is also there. Now, my lord, will take to my affidavit for a moment. My affidavit at page number, my lord, page number 38. Now, let me describe what has happened, how it has happened. Page number 38, my affidavit. Now, this is what is, we have crystallized from the records, my lord, that this is what has happened. A conflict between students occurred on 8/8/2023, both within and outside the campus of IIT Guwahati. Students from the BTech third year and BTech fourth year and some senior students were involved in the said unrest. It is stated that owing to the conflict and unrest which had occurred on 8/8/2023, on 12/8/2023, further unrest affray had taken place both inside and outside the campus of IIT Guwahati. It is further stated that the local people, shopkeepers, also got involved in the said affray and also got seriously prejudiced by the said act of the involved student. It is worthwhile here to mention that the competent authority of IIT Guwahati, upon being informed immediately decided to investigate the matter during the course of disciplinary proceeding. Involved students, security staffs of IIT Guwahati has deposed. Now that deposition is there in the with the EML, with the records. Those depositions are there now. Now, my lord, will turn to page number 43. My lord. Disciplinary committee instructed all involved students to remain present before them on 14/4/8/2023 and 16/8/2023. The students were made aware of the charges against them, and accordingly the committee proceeded with their inquiry, wherein they had interacted with the students and advised them to assist them to find out the person responsible for the affray and unrest which had taken place. As per the petitioner, the disciplinary committee had interacted with him on 14/8/2023 and on 16/8/2023. And before the disciplinary committee, he has submitted a written statement. Now, let me, before reading it, my lord, there are two written statements which is there in the record. My lord will see what he has stated where. Now, one written statement, my lord, we have quoted here. It is with respect, this is the it is there in the annexure A, the original copy is there. Sorry, the Xerox copy is attached as page number 70, my lord, if the my lord wants to see that original EA. His another statement is there on the record that I'll also take this honorable court through, but in due course, my lord. Let me just, my lord wants to read page 70, my lord.
Yeah.
Yes. With due respect, I want to tell the date is 14/8/2023. He says that. With due respect, I want to tell the happening at the KB gate. I went to KB gate through Tarjan shop and saw a crowd gathered at the KB Golambar. I went near there and then I came to know that someone has beaten my friend Dipanshu. I stood there for 10 minutes approx. Then again, some people started entering through the KB gate. After some time, push and pull started between people. I saw there that one Rohit person held a stick and beat up third year student Keshav. I could not see much there. So I went through the crowd and entered Disang to the side gate. After few seconds, side gate was closed. I saw that crowd dispersed around the side of the Disang. After that, BC, SGC and GS welfare came and pulled the chaos. Next page. I am sorry that I got involved in such matter as I have no relation with the within the scenario there. My lord, now this word, no, my lord, has a context again. Very surprisingly, they do not disclose everything in one go. Now, my lord, this I will explain from the original records again, how this has been done. Now, what has happened thereafter, my lord? One minute. Sorry, 43. Yes. Now, my lord, we'll turn to my lord has seen his statement. My lord will note that he said that I am sorry that I got involved in the statement and in relation to such and such. Now, my lord will again come back to the my paragraph, which I was looking, I was assisting, my lord. Page number 43. Page number 43, my lord will come back kindly. 43.
Yes.
Yes. 44, I have read. This is the statements copy. What has happened thereafter? Thereafter, disciplinary committee, which comprised of 13 members, deliberated the entire matter, and disciplinary sanctions were issued against total 16 nongs of students, including the petitioner. It is pertinent to note that the committee members specifically recorded that dissatisfaction in the manner the involved students tried to hide facts and misguide the committee in its investigation process. This goes on to show that the petitioner and the others were involved in the affray and unrest which had occurred on 8/8/2023 and 12/8/2023, were acting in concert and perhaps acting with common object. It is further important to note that petitioners and others involved students were part of separate groups who had created participated in the unrest and affray which had taken place on 8/8/2023 and 12/8/2023. Thus, in the instant case, due to the nature of incident and uncooperation of the involved student, the respondent authorities decided to treat erring students at par and impose punishment to everyone, including the petitioner. Petitioner was found violated of such and such clause. Accordingly, this letter of 29/9 was issued, whereby certain disciplinary sanctions were imposed upon them. Para 4. It is stated that firstly, the unrest and affray which took place on 12/8/2023 stemmed from a pre-existing dispute or fight which took place between the students on 8/8/2023. Secondly, the conflict escalated primarily because significant numbers of the students involved in the incident were in an inebriated state. Thirdly, the incident of 8/8/2023 and 12/8/2023 involved two distinct groups of students encompassing both senior, junior, and senior. Now, show me this original record. Take it out of the page. Involved two distinct group of students encompassing both senior and junior students. Group 1 consisted of students from various academic levels from BTech third year, BTech fourth year, PhD scholars. Group 2, of another hand, consisted of BTech third year students and BTech second year students. Following included in the group 1, group 2. Now, my lord, we'll take the original record, the big file, my lord. I'm sorry. Can you access the code?
Yes.
My lord, we have already marked. There's an anti-ragging committee minute is there. Page 13, my lord.
13.
From the bottom, my lord. From the bottom, it will go up.
Is it flagged?
Yes, my lord. It has been flagged, my lord. My lord, my colleague will assist, my lord. He'll give the file, my lord. He will open it out immediately. This record, my lord, was placed before the BOG also. An argument why I'm taking this, showing the original record, my lord. I have craved leave, my lord. I'll show. I have craved leave that I'll produce original record. My lord, argument has been made by the petitioner side that this grouping which you have stated in another case, those 5 cases which I have stated before, you have not stated there. In this case, you have stated because there are almost identical cases been filed before. In his rejoinder, he has said this. This grouping is new. Before, you have not stated. After now, in this petition, you are not trying to develop your case. I'm sorry, that is not correct. In that rejoinder also, which he has filed, in that my reply, it was stated that the original records will be produced during the course of hearing, because we have filed that reply very quickly. The court was consistently here. So we filed the reply and we said that we crave the leave. I am only deliberating, my showing the conclusion part, my lord, and the grouping part. Rest of the report, my lord, I will take this court through, and when I the relevant part is the conclusion, my lord. The ARC determined that the conflict in question, my lord has got that line, conclusions. ARC determined that the conflict in question involved two distinct student groups encompassing both senior and junior students. Specifically, group 1 consisted of students of various academic levels, including BTech third year, BTech fourth year, and PhD scholar. Group 2, on the other hand, consisted of students of third year students and MTech second year students. Consequently, it is evident that the conflict cannot be categorized solely as an issue between junior and senior. So the grouping they have done. So on the group 1 was Shashikum P. Marak. My lord has got group 1. Group 2, Akshat Pratap Singh, Boni Hajarika, Archit Chauhan, Rishi Harit, Bhabesh Sharma, Yash Sharma. My lord will see at the side part also, they are mostly from the fourth year. Fourth year, my lord is saying these are fourth year people. Fourth year. Yash Sharma, fourth year. Rohita Sharan, Department of Civil Engineering, he is PhD scholar. Group 2, Pradyum Dikshit, Department of Chemical Engineering, BTech third year. Yash Raj Verma, BTech third year. Dipangshu Pofare, BTech third year. Kumar Gaurav, the present petitioner, is BTech third year. Aman Ravi Singh, BTech third year. Adesh Kumar Patra, BTech third year. Saranjit Singh Dhillo, MTech second year. Vivek Sirote, Vivek MTech student second year. The committee additionally determined, in accordance with the finding of SDC, that the altercation initially, my lord has seen that last year, initially commenced outside of the institute premise. There are evidences that indicate the individuals from the local community were physically involved in the assaulting the students. This raises the possibility of injuries sustained by one of the students could have been infected by the members of the local community. There is an absence of compelling evidence to support the claim of senior students were responsible for assaulting juniors. Thereafter, the ARC member carefully findings SDC and they give it. My lord, so the groupings which we have produced in the para number 4, my lord, is basically the groupings which are there on the record. It is not from some thin air I have pulled out. In that affidavit also we have stated, because that affidavit was filed very quickly, my lord, that we will rely upon the original record at the time of the hearings. Now, my lord will keep the records for a moment. I will again come back to my affidavit. I will now back and forth go. My colleague will assist this honorable court. Now, what has happened thereafter, my lord? My lord, so the argument, so this is the initial, how the disciplinary proceeding A is there, what is the incident has happened, how the two groupings were there. Then my lord will see para number 5 of my reply. Subsequently, petitioner preferred an appeal. In the said appeal, my lord has got that word. The said appeal was placed before 116th meeting of the BOG Board of Governors, which was held on 23/12/2023. After the deliberation, the BOG decided to uphold the decision of the SDC, and the same was accordingly communicated to the petitioner on 24/1. This is, my lord, 24/1 order is that annexure 4 of the petition, which they have previously challenged. It's pertinent here to note that 115th BOG meeting held on 16/6/2023 and the petitioner's appeal dated 17/10/2023 placed before 116th BOG, which took place on 23/12/2023. Thus, there was no delay on litigacy. Now, this latest point, let me explain, my lord. Argument was made that IIT Guwahati Institute BOG has caused delay. My lord will see, take up my statute and see clause 2.2 from the statute. That how how many times the board is supposed to sit. Board cannot sit as the petitioner wishes, unfortunately, my lord. 2.2. The board shall, I'm sorry, my lord. Page 2, my lord. Clause 2, 2.2. My lord has gone? Yes. Board shall ordinarily meet 4 times during the calendar year. So only 4 times, my lord. So, my lord, what I'm trying to tell, my lord, is this, that 115th BOG minute had taken place on 16/6/2023. SDC decision came on 29/9/2023. He filed appeal on 7/10/2023. On the immediately after the BOG minute, BOG which set was 23/12/2023. That BOG meeting, the matter was placed. How there is a question of delay by the authorities? You challenge this, that no, board should sit as much of time. Have you approached this honorable court in the interregram? If you would have approached this honorable court, the honorable court would have granted relief like others have been granted, not been approached. Now, my lord will interestingly will see his appeal for a moment to the BOG. The argument was made that neither SDC nor the BOG has applied their mind. My lord will see page number 35 of the writ petition. My lord, I have read his statement. Is in his statement, my lord. Completely a contradictory picture was projected before the BOG, my lord. And it was expected from them. If BOG is so, yeah, they will be so gullible that they will not read through this ruse of them. Page number 35 of the writ petition is the appeal which he has filed before the BOG and made the contention that neither BOG nor SDC has applied their mind. See the contradictions, my lord. We hope this letter finds you well. The original record is there, my lord. Let me read from this. At least there will be no objection on this. In connection to the SDC recommendations, actions taken against us, none of us violated the code of conduct cited against us in the letter of SDC actions. For your kind information, we would like to highlight the following points to be considered in this EA. This is addressed to the director regarding EA, their appeal, petitioner's appeal. On 12/8/2023, there was some argument between the students and locals outside the campus. Thereafter, the verbal arguments were followed between students inside the campus. It is utmost important to note that no physical violence was noted or promoted between the students inside the campus due to misunderstanding. Whatever arguments, only verbal, my lord, happened, were resolved between the students peacefully on that day. On 8/8/2023, it was only limited to the verbal exchange between the students near Disang hostel. It is of the highest importance to note that there was no violence of any kind between students and the matter was resolved between the students peacefully on that day itself. It did not involve all students. It did not involve the same students that were involved in 8/8. SDC actions are unfair and we request proper view for all until proper review is been done to stay the decision such and such. Additionally points out, my lord will turn over leaf and see petitioner name last, Kumar Gaurav, item serial number 11. Is their document, my lord? They have annexed it. Now, surprisingly, my lord, that document which I have attached and which I have quoted, my lord, for the convenience of this honorable court, at page number 44, he is submitting before before the SDC, that I went through the Tarjan shop and saw a crowd gathered near KB Golombar I went near there and I came to know someone has bitten my friend's Dipangshu. Before BOG says no verbal, only verbal argument. Nothing has happened. All clean and hunky and dory.
How long are you going to take?
My lord, I will finish it up. I'm sorry, my lord. I will finish it up.
No.
I did not wanted to.
How long?
My lord, if I go through, my lord, I have the entire 2 cases prepared. I will cut short and probably I will now. My lord, I have also prepared my written arguments. If my lord thinks
Okay, yeah.
I will give my written arguments and then my lord will. But I can go on and I can show the original records, what they have said, done, shown these original records, page number wise, I can show this quote. Let me just complete this point, my lord. So, in one hand, before SDC, he says, so people have bitten. I have seen people beating my friend. There is tooth is being broken. Somebody, Archit, pointed out, broke everything. Before the BOG, complete version is changed. Thus, there was an active concealment of fact by them at all stages. Changing versions here and there. I told my lord last occasion, this was nothing but a fight club situation. So whatever happens within the fight club, that remains within the fight club. It doesn't go beyond. That was been done by the students. I'm not commenting upon their loyalty towards each other, but what I'm trying to tell, the disciplinary authority was left with no other option. None were there to assist, my lord. Now let me, my lord, I'll wrap it up immediately. Let me now just show some statements, then I'll immediately wrap it up. And same thing will follow for the year. Because these statements are now important, my lord, how these things have proceeded. Now, my lord, will see the original records, see what everybody has said about. Yes, my lord. Sanjay, take out the statement of first. My lord will see the statement of Kumar Gaurav, my lord. Apparently, it starts from the Kumar Gaurav. My lord, Kumar Gaurav. Kumar Gaurav, no. Adesh Kumar Patra, my lord, I'm sorry. Adesh Kumar Patra. Adesh Kumar Patra.
Yes.
My lord has got the other.
Yes.
Open.
Adesh Kumar.
My lord has got it. Adesh Kumar Patra. Yes. Page 94 it starts, my lord. 94 it starts. The top of the A, it has been written page number 94. Small, very small, Adesh Kumar Patra.
Okay.
So this is first statement is at page number 94. I think SCB also wants me to stop, my lord. I'm going too long. Let me read one statement of him and then I'll refer back to this. The court will say what Adesh Kumar Patra said, how this incident had happened. 14th August, Adesh Kumar Patra. Next page, my lord. Page number 93. 92 starts, I'm reading 93. My lord, got it, 93. Next page, just next page. It starts chairperson SDC, incident on 8th August. 93. Got it, my lord? Yes. Myself, 5 minutes more, my lord. I'll not proceed beyond that, my lord. I'll wrap it up as myself, Adesh Kumar Patra. My lord has got that line of third year Kamang Hostel, room number such and such. On the night of 8th August 2023, I was with Kumar Gaurav, Dhisang Hostel. So Kumar Gaurav is the petitioner here. Aman Ravi Singh and some third year students. All I don't know. Petitioner number 30, in item number 30, he did not knew his name on that time. I just know Boni. Lohit 4th year and Bhabesh Bhaiya. With them, there were 4 to 5 more seniors. My case is this. The petitioner in 30 was there. Yash Sharma was there with them. He did not know the name. I'll show how it comes out. Were there. They started taking PDP of us, asked our name, intro basically, and then they told me to do some sort of salami. in which I had to hold my genitals in front of them. I denied as I was interacting with them for the first time. They were strangers to me. They started giving abuses to my family, and then all started threatening me. I still denied to do that. Then Bonnie and Bhavesh and few others started beating me. Few others included Yash Sharma. He did not knew the name a lot on that time. Now, they tore my t-shirt. Bhavesh Sharma and few others started beating and tore my t-shirt. I even have that with me. They punched me and beat me, all 4 or 5 of them. Then when I came through KB, that is KB gate, that KB gate which he was referring, Archit, Lohit, Fautier started threatening me. I went to my hostel on 13th August 2023. There, Tharnad sir called me to Lohit with G7. More professors checked my phone and locked my room. I told them the whole story. Then after waiting for 3 hours, when I went to take my phone, sir called my papa and told everything. After that, on 14th, they asked again me everything. Yesterday, I also submitted, and now I am also submitting this one. Now, my lord, from this, it appears that the petitioner was there. Petitioner number 30, 31 was absolutely there. Adesh was beaten. Adesh Kumar Patra was beaten by few fourth yearites. I will demonstrate that petitioner number 1 was there, or with whom they admittedly had an interaction which is not pleasant. Now, my lord will take a statement of Vivek Saraote. This is Vivek Saraote, my lord, page 50, 50, my lord. This gives more context. Vivek Saraote. My lord has got it. Name Vivek Saraote, 8 August. I went with my friends Vishal to the Ghat. They stayed with me till 8 p.m. After that, 3 third-year students came from my hostel only. Gaurav, Aman, and Adesh. So, there is Gaurav is Kumar Gaurav. So, Kumar Gaurav went to Ghat on 8 with them. Vishal left and I stayed with these 3 people. After a few minutes, one of these 3 went to light a cigarette and some harsh talks took place between them. After a few minutes, almost 8 to 10, all fourth year came and started scolding and misbehaved and were using words PDP. PDP is that way, personal development. They call it, we are taking PDP, so it's ragging sort of a thing. I don't know what this PDP that is. After this, some of them started pushing these 3 in the name of PDP. So I stayed there and grabbed these 3 forcibly to the college, my neighbor's room, and came and took them to the hostel. 8. On 12th, the same thing escalated the fight. On 12th, there were many people. I only knew people from my hostel. The reason for this fight was the little pushing and abusing which happened on 8. Fourth year again came and started scolding Disang third year for not obeying and not respecting them. Due to the noise, local people owner came and advised all the people below on the ghat to leave the place. But after knowing the strength of fourth year students, they were almost between 20 to 40 in the number. He went to his shop. When all the people came near his shop, he started beating with sticks whoever was there, shouting and seeing the involvement of local people. I grabbed Pradyum Dikshit and came to the KB gate by walking. After that, I went to the hostel and stayed there for a few minutes, came back to the main road to the Lohit hostel. I am not reading, the last part is not important, my lord, at least at this point of time. So, my lord, from the Vivek Sarato statement, it is absolutely clear that there was a fight with these three people, and it started from pushing and shoving. Now, my lord will see the Kumar Gaurav statement now. Kumar Gaurav statement, my lord. As I told my lord, there are two statements of him. 5 minutes more, my lord. I will wrap it up. Just showing the statement. My lord, we have marked it. Probably it is page number 82. My lord has got it. That flag is there, my lord. My lord has got it.
Page
82, my lord. Probably it is. Probably it is 82, my lord. That flag was there, my lord. Flag is there.
Kumar Gaurav.
Dipanshu Papara statement of Dipanshu Papara. I'm sorry, my lord. If am I be allowed to, my lord, to read slowly?
No.
I will give the markings again. My lord, may I?
Yes.
Dipanshu Papara. I got it. Page number. Yes. I went. दादा अपनी फाइल उठी वो ही खुलाई बोला गली immediately. I went inside the KB gate coming from the Tarjan shop. Tarjan shop is basically, I checked out it is basically a wine shop, my lord. At the Golambars of KB gate, some people were gathered. More people started coming inside. After pushing and after passing the Golambar gate, people started pushing and pulling. The crowd started moving on the Disang Gate road. In this way, I saw a student, Rohit, I don't know him personally, coming and running and hitting Keshav, a third year right. With a stick, he pulled out from the KB sapling. There were a lot of people in the dark, I hardly recognized anyone. So the fight first. Yeah. I went to the Disang to the KB with the crowd and entered Disang via side gate. After some time, Gymkhana VP and GS welfare came. There. Side gate was closed and no one was allowed to go outside the guard. I went to my room. Then, this is very important. Let me read this slowly, this part. What he says then. Then I texted in my school friends group chat. आज लड़ाई हुआ बहुत मारे. Hello. Then he says in the statement that I stated this thing in a joking manner. IIT authorities, they have looked, they told my lord, they've taken the phone also. Now, my lord, this statement has to be read with the last statement where he says, I am sorry I got involved in the fight. He said, Ladai we both mare in the text groups. Text it. Then immediately realizes that something he has said out of turn and he changes his version and says, no, I have said this thing in a joking manner. That statement we will pull it out and show this honorable court. Therefore, my lord, in the last statement which I have read, and I said that honorable court will mark this line where he said, I am really sorry I got involved in such matters, is this, my lord, is this basically. That he got involved in the fight, he was involved in the fight previously also, afterwards also, there was an admission. That is the reason, my lord, the authorities come to that conclusion. Authorities come to that conclusion that he was involved. My lord, I'm just going to give the now page numbers. My lord, I will not read everything because this will, I don't want to trouble the court more. There is another statement of somebody called Aman Ravi Singh. He also says the same thing, how the fights happened, how these three people were there. Kumar Gaurav, him, others were there. Now let me read one little 2 lines from a statement of somebody called Dipanshu Papare. He was also there. Dipanshu Papare's statement, my lord. I, Dipanshu Papare, such and such, a final year BTech students, Department of Chemistry. I went to the ghat to drink alcohol with my friends, namely Pradyum, Yashraj, Gaurav, Aman, Adesh, Vivek, such and such. After some time, my friend Pradyum such and such got into a fight. I'm not reading further because the idea is to that these people consumed alcohol and entered into a fight. Now, my lord, from this background, the SDC started the proceedings. I will just now point out the page numbers of the SDC minute, and my lord will see what SDC has stated. It has been shown that no charges, nothing has been, all these things. My lord will turn to running page number 107 now. Running affidavit, my affidavit. No, I think 107 and 105, my lord. I think no, it is there in his rejoinder. Rejoinder is there. His rejoinder is there. Rejoinder, page number 107. My lord, page number 107 is the rejoinder, my lord. Into this background, my lord, the SDC starts the investigation. Now, law is this, my lord, the disciplinary authority, the court cannot reappreciate the evidence and come to a different finding. The evidence which is laid down before the disciplinary authority has to be tested on a scale of a reasonable person. In this case of an educational institution, the scale is further below. With all due respect, my lord. Let me show the deliberation part only. That is, I think, page number 109. My lord will bear with me a minute more, my lord. A report is complaint, deliberation. A report was received from an incident of unrest among the students in the midnight of 12/8/2023. The report mentioned that many students from other hostels assembled in intoxicated conditions, motive of creating violence. Deliberation. The student mentioned above were given an opportunity to present their cases before the committee. In the meeting, the committee heard the complaints and also took note of the video footage supporting the complaints. Committee understood the conflict took place on 8/8 and continued at a similar unrest situation took place on 12/8. So linkage was shown, even though they were repeatedly saying no, only 12/8, no, only not 12/8. It's they looked into what has happened on 8/8, then 12/8. To get more insight of the incident, the committee has called Kishore Kalita Sansa's meeting for the security section. Kalita Sinha explained the incident of 12/8 and submitted the written statement. This observation was extrapolated to say no, committee only excluded other statements. Sorry, my lord, that is only recording that the statements of security guards were of 12/8 incident. During interaction with the students, names of the students were revealed who were related to the incident and were called to attend the meeting by the committee. Students attended the meeting and the committee interrogated the students regarding the incident. SDC deliberated on this matter, and during interrogation, none of the students helped the committee to get the complete truth, and everybody tried to hide and misguide the committee. My lord will now just see 2 lines at the last page, my lord. What the committee has at the last has said, that was not been, unfortunately, here, my lord, 124. Thanks. Peruse the receipt of the complaint, my lord has got that last page of that 124. I'm sorry, not last page, 124. Pursuant to the receipt of the complaint of the SDC of this institute, investigated the matter thoroughly and following laid down guidelines, it was found that the alleged act of physical violence that happened between the students of this institute on 12/8/2023 was due to some pre-existing personal conflicts among some of them, which got escalated as some of the students were in intoxication. No acts regarding ragging was established. Investigation was there. So, only by reading one line from somewhere and stating that SDC did not look into what has happened on 8/8, that is not correct. My lord will stay on that page. Let me now make another submission. This was all of a sudden pulled out as a rat from an habit. Rabbit out of an hat, and and submission was made that look, the SDC was also not properly formulated. My lord, that submission was made. That submission was made by showing the code of conduct, I think 4.1.5 of the code of conduct. That is the A, which says the constitution of the A. This is my lord. Constitution of the disciplinary committee. That code of conduct, that page. I'm sorry, my lord. I'm rushing through. Probably I am missing something also, my lord. My lord will 1.A. 4.1.5. That is page number 30, my lord, of my affidavit, I think. Writ petition page number 30, my lord. That submission was made, my lord, that look, not only the SDC did not look into the evidence, but this formation of the SDC was also not in pursuance of 4.1.5. That argument was canvassed. Now let me deal with this argument, my lord, for a moment. It was been said that student Gymkhana member was not there. Student Gymkhana member in 4.1.5 is there as a vice president of student Gymkhana member. He is supposed to be there. That is the argument made by the petitioner side, that you were in so that you did not put student Gymkhana member. My lord will turn to page number 107 of that same rejoinder and see how fact-free arguments have been made, my lord. It's an absolutely fact-free argument, my lord. Serial number 12. He is a member of student Gymkhana. Who is he otherwise? Then the argument was made. My lord has seen this. Serial number 12, first page itself. Mr. Golve Priyosh Ashok, Vice President, Student Gymkhana Council, is there on that meeting. How can it be said that he was not there and is a violation of 1.4.1.5? Then the argument was leveled that your Dean Student Affairs was not there. My lord will see next para itself, that your Dean of Student Affairs is not there, your Associate Dean of Student Affairs were not there, and you have conducted the meeting. The argument is this, my lord. Professor of Anamika Barua, Dean of Student Affairs, and Amresh Dalal, Associate Dean Affairs, could not attend the meeting such and such, and were outside. For that specific requests were made in the original record. Those pages are there, my lord, where they have relieved the charge. Nowhere it has been said that the Dean Student Affairs is not there, you cannot conduct the disciplinary proceedings. Then the argument was made that student counselor was not there. My lord, students counselor had made a request before the BOG. That BOG, that record has also been given, that we don't want to be part of the disciplinary proceedings, because the student counselors are who? Before them, students basically express their all fears. So if before them they express all fears, they cannot be participate in a disciplinary proceedings where student might have admitted some mistakes. So it will be basically self-incrimination for the students. That student in the student counselor would have said, yes, I got drunk on such and such day and participated in a fight. To maintain the confidentiality of that system, my lord, the student counselor made a prayer before the BOG that absolve us. Accordingly, the BOG has absolved them. Now in no SDC, they are part of it. No SDC. It cannot be. The office himself hears everything. It is like my lord, father and the practitioners. If I confess something before the father, tomorrow can the father be put before the court of law? And it is in secret communication. Now, my lord, I will address the last point, my lord, which other points are there. I don't want to go further because my written submission covers this. An argument was made that no show cause notice was given, nothing was given, 4.3 violation. My lord, unfortunately, my lord, what is not been appreciated, that even though show cause notice not been given, charges were explained to the students orally during the meeting itself. My lord will read 4.3.3. Does 4.3.3 anywhere states that show cause notice is supposed to be given? It only says that the charges were supposed to be explained. Let me just take this to 2 minutes more, my lord, will bear with me. SDC will investigate.
Which one?
My lord, 4.3.3, page number 31, my lord. Thank you. Last part, my lord, 4.3.3,
Yes,
it was been said. My lord has got it?
Yes.
The charges recommended by SDC shall be referred to the chairman, Senate, for approval and will be reported to the Senate. Upon approval, the charges will be intimated by the HOS SA to the concerned people. Now, my lord, here, rightly, wrongly, my lord, I am not on this. The first point is this. Charges were explained to the students. Point two, my lord, charges here, what the disciplinary authority meant are the disciplinary sanctions. Means what, my lord? Let me, this is little fine up on, let me, my lord, try to put it as here. My lord, what they have understood by this, the disciplinary authority at that point of time is this, that the disciplinary sanctions which have been there at point number 5, that they understood as in charges. These are the final charges because this is a recommending body only. Punishment is not given by the SDC. Punishment is given by the Senate ultimately. Upon acceptance of the recommendation. They, in their wisdom, thought he wants the disciplinary recommendations. This is the charges that they thought. This is the charges. Once it has been approved by the chairman, it was been communicated. Senate chairman, it was approved that charges, and accordingly by a letter dated 29/9/2023, the same was communicated to the petitioner. Whether this interpretation is correct or not correct, that, my lord, with all due respect, can only happen before this honorable court if the repugnancy of the rule is challenged. Until and unless the repugnancy is not challenged, the petitioner is not allowed to take an interpretation which is not in line with the disciplinary authority. Because the first part itself is says, interpretation of the provisions of code of conduct may be requested by the contracting dean affairs only. The interpretation, power of interpretation is only with the dean of student affairs, nobody else. Okay. At that point of time, my lord, they have thought about this. Let me, I will now complete, my lord. I will not. Just two things with regard to the same arguments will follow. Now, my lord, with regard to this, yes, Sharma, my lord will see that original record again. Sir, let me just see that original record.
I don't think you can conclude today.
My lord, I'll finish. I have nothing more to submit. The same argument will follow. I will not submit. Just 2 minutes more. I wanted to show that Yash Sharma has not participated in any. He has also not done any academic activities. Not sorry.
You got the written argument.
Yes, my lord, I've done that.
Then that is fine. That much will do.
Original record, my lord, will see that original record, my lord, annexion number. Let me just see annexion number 3 of that original record, my lord, which I had submitted. Annexion number 3. His attendance is not there. And that has been written also on the top of it. Let me just, my lord, Yash Sharma part. On page 2 for the Yash Sharma, my lord, they have stated completely. Now, my lord, I don't want to trouble this court further. Just 2 judgments which I have. I'll and Sharma, my lord, and Mala judgment I'm referring upon. And Mala, I think. And Mala and
citation.
Yes, citation I'll give it, sir. Citation is Manu, GH. 2009 1 JLR. Thank you, Sanjay. 2009 1 JLR. LR 534. Para number 7, my lord. And my lord, I am relying upon. This is another judgment by the Madras High Court by BS Baba Ramesh versus Central Board of Student Secondary Education Regional Officers, Headmaster. This is WPC number 908, that judgment, my lord, where the Honorable Madras High Court has said
BS Baba
Ramesh
versus Central Board of
Secondary Education. where the court has said, my lord, repeatedly that you cannot expect the student doesn't follow the disciplinary way, that cannot be my lord. That is how, my lord, I concluded. I do not have anything further. Written submission I am giving. My lord, written submission is there, my lord. I will before the court, and my lord, if something is required from my side, my lord, I will. Written submission is there. My lord will take my written submission. I am closing my argument. I think. My lord, I'll.
Yes, Chairman, the counsel for the petition. Also heard Mr. every day.
My lord, we'll conclude the proceedings today, my lord.
IITJ. He has to reply.
I may read some reply.
Acha,
Many new things.
List the matter for further hearing. When do you want?
On 1st of October.
That is not a hearing week. It is a motion week now. Next week is a motion week.
My lord, I think we both can submit our written argument.
Different thing, but another.
Then we can have it after the puja.
My lord, just my lord.
After puja.
Not after puja, that can be concluded, my lord. I shall not take much time, my lord.
Let him complete, my lord. We'll sit.
Issue is there's no time. Next week there's no this thing. Thursday there are many cases listed.
On 30th or 1st of October. No, actually.
First of October, I told you already the next week is a motion week.
In that record also, I think it's the original copy is even on.
Page 27 to Actually, I am not there for 25, 26. I am out of station. Otherwise, I would have fixed it on 26, 25, 26 also.
Tomorrow, day after?
But I am not. I shall
Then
not be
we'll
there.
have to do it after puja then. We'll give a date.
Only on 1st October it can be fixed when I shall not take much time. That is main thing. I shall not matter be concluded on that day. If you
I am not fixing next week.
If you don't.
24th October.
My lord, 1 minute. My lord is sitting on 24th, my lord. Well, my lord, just that, my lord, I may not be there on 24th, my lord, if it is something. It's 28th, my lord, if it fixes, or 29th, anything.
October.
29, 28, 29.
21, no. Can you be 22nd October?
I'm not there in that week. That is what I'm telling.
22nd.
I'm not there in that week. That is the reason I'm telling the requesting the court.
On 24th though?
I'm not there in that entire week, sir. Sir, otherwise let him finish. Whatever he wants to submit, let him submit, my lord. My learned senior, my colleague will be there.
I have just to reply, my lord. They are giving written argument. I have just to reply. Oh, so it will be 22nd.
Okay, you also give your written argument.
I shall give, but let it be on 22nd October. And they are giving the written argument. I shall also.
Okay.
Let it be 22nd October. 22nd.
Or 24th probably. That is the hearing day, no?
22nd is the hearing day.
Tuesday.
22nd is
just after the day of reopening, my lord.
22nd is Tuesday.
24th.
24th.
My lord is keeping the original record with it, my lord.
No, you keep it.
My lord. Then on that day, my lord, my colleague will produce and will give the written arguments also. Or it is already given, I think, my lord. My written arguments is it there in the record? I'm sorry.
You can take back the request, but leave the books.
My lord. Deeply obliged, my lord. I am so grateful, my lord.
May I please, your lordship? May I please, your lordship? Item number 24, my lord. May be taken after day after tomorrow, my lord. Last 2 occasions, I'm trying to upgrade, but
Day after tomorrow,
my lord, please, my lord. It's a humble request, my lord.
Okay, and request made by Mr.
Ahmed.
Under counsel for
Top of the list, hearing list, my lord.
again on 26th.
Top of the hearing list, my lord.
No.
Obliged.